release of property, it can be disposed of within the minute below. Can it be listed tomorrow?
Give. Not tomorrow, but you give it.
Pardon me, Lord.
Yes.
Your Lordship, it is a criminal appeal which your Lordship had allowed last Wednesday. That today is the date of surrender.
Give.
Lord, I pray if it can be taken up at 2 o'clock.
No, not it.
Lord,
You
you surrender the date of surrender today.
It's all right. Why have you moved?
Too
late.
Lord, as per the registry, what I have gathered, because the matter
When have you moved the application?
last Wednesday, my Lord, your Lordship had
When the interim order was given?
Your Lordship, 3rd of July.
Other than wait, you surrender. Lord, please do.
Your Lordship,
Yes,
selected for today.
Your Lordship, 3 cases have given repeated memos, but there is no listing. In 2 cases, the repeated memo has been given.
Give memos. All memos you give, we'll see. Give the memos, we'll see. Yes.
I beg pardon, my lord. Jail criminal number 13/2021. Your lordship knows that there is a Supreme Court decision that if appeal is pending for more than 5 years, a bail petition may be considered. I have filed a petition.
At least it. Okay.
The matter will not be listed since 7 years.
Are you in custody?
Criminal appeal.
Oh, appeal.
More than
Only the custody was
custody more than 8 years.
Sentence?
Last year,
What is the sentence?
sentence 10 years.
10 years. Okay, good.
Memo file next last day.
Have you written that at the top? Out of 10 years, 8 years undergone, have you written it? Okay.
5 years custody.
Give. Write it at the top. Write it at the top. Okay, start.
Weekly list item 54.
Weekly list tomorrow. We'll see. No. Let us see weekly list what happens. I can't adjourn it like that. Okay. We'll see.
I am saying the actual small prayer is lordship. Similar case has been disposed by your lordship in criminal appeal number 350.
What do you want?
Let us take up.
When it will be taken up, tomorrow you come and mention, come with give the order to the other side. We'll dispose it up. If that is similar case. Okay. Okay. Yes. Start.
Your Lordship, item number 40 of the weekly list, Your Lordship. Out of 10 years of conviction, the appellant has undergone more than 9 years, Your Lordship. Item number 40 of a weekly list.
40.
Yes, Your Lordship.
What do you want? You want already undergone?
Yes, Your Lordship.
Right. Tomorrow, huh?
40.
40. Weekly 40 tomorrow. Okay. And the other mentioned weekly.
44.
40?
44.
No, both the matter. Tomorrow you first item.
Yes, Your Lordship.
Total sentence?
Total 5 years.
5 years. Write down at the top, huh? Write down at the top. Out of 5 years, 1.5 years undergone.
1 year, 6 months.
With clarity you must write. Yes. Yes, next. First.
Weekly daily any mention from item 1 to 5.
This is supplementary, huh? Okay. Yes.
Item 6 to 15. 16 to 23. 24 to 30.
Item 29. I play this matter column next week.
40.
29.
29. Yes, what do you want, sir?
It will be matter be column next week.
Sorry?
Column next week.
Is there any stay?
No.
Okay. Next. Yes. Yes.
31 to 37. 38 to 41. 42 to 46.
Item 42.
Yes.
For adjournment to.
Is there any stay operating? Oh, criminal appeal. Okay. Resolve. Okay. September, huh? Those who are asking for adjournment, good September. Yes.
47 to 50. 51 to 53. 54 to 57. 58 to 62. 63 to 67. 68 to 73. 74 to 81. 78 window.
Withdraw. 78 withdraw. Yes.
82 to 84.
Yes. Anybody in VC? No. Yes. Yes, start.
Item 1.
I am appearing for the informant, my lord. Praying for Passover.
Informant means opposite party number 2.
My-
What is this matter? It's simply getting adjourned time to time.
Passover.
Sorry?
Maybe Passover.
Passover, okay, Passover. Passover, yes.
Item 2.
Conviction, your lordships. The appellant was convicted under section 366 and 376(2)(n of Indian Penal Code.
It's not admitted yet.
My lord.
It's not admitted. I will just, subject to the appellant paying and. You deposited that money,
My lord, he is in custody right now.
100 rupees something,
My lord,
100 rupees.
I'll,
I'll admit it.
yes, sir.
I'll simply admit it.
Yes, sir.
Admit, huh? With the wide order dated 15/10/2025, delay of 37 days in preferring the appeal has already been condoned, subject to payment of the cost of rupees 100 to the Advocates Welfare Fund of the local bar association. Then counsel for the appellant submits that the amount has already been paid. The cost has already been paid. And admit, call for the TCR and the call for TCR and fine amount dispensed. And what are the 3 applications?
My lord,
Other 2
one is for
bail
the
application.
bail, another for the
Yes.
stay realization of
Is
fine.
allowed. Stay realization of fund allowed and bail. Yes.
Bail, your lordship.
What is the sentence?
My lord, sentence is for 10 years for 376(2)(n.
Okay, then issue notice to the complainant, complainant, insofar as the application of bail is concerned, and lease the matter to be served to the IIH also, lease the matter after 3 weeks. Yes, after the service is completed. And TCR is called. After the service on to the complainant is sufficient, and the TCR is lease the matter. Yes.
Item 3.
Yes.
7 years convict, sir, for the offense under section 376(1) and section 4 of the POCSO Act.
Okay, notice. Also notice for and admit. And there is no application.
My
Any
lord,
fine?
My lord, the 2 appeals from the jail, my lord, in time. And the second application, my lord, I have filed. And there is a delay.
How much?
160 days.
Or delay is condoned for the reason stated in the application. Second item, delay condoned, realization of the fine. Take. And insofar as base application is concerned, notice. Take. Okay. Call for TCR and all. Yes.
Okay. Item 4.
Convicted under section 363, 376, clause 3 of IPC. Read with section 4(2) of POCSO Act. Sentence order by RI for 20 years. With fine rupees 5,000.
So, yes.
This is RI for.
Yes, allowed. Yes, next.
Item 5.
Yes.
Obviously, this topic matter. The offense under 20B NDPS Act, there is sentence.
NDPS,
Yes, ma'am. The sentence under 4 years, ma'am.
4 years.
Yes, ma'am. And in meantime, I have more than 1 year in custody.
Fine. Admit, call for TCR, realization point. And how much you undergone?
1 year, 1 month is already on bail.
Okay, issue notice on the application for bail also, lease the matter after 3 weeks. Okay.
Item 6.
May I please not
Yes.
file for conviction for the offense under the 10 of the POCSO Act.
10 footnote. Admit.
And the petitioner is in custody since to last week.
Okay. Stay realization. Yes.
Item 7.
Same.
Your lordship, notice. Notice.
Yes. Yes, next.
Item 7.
May I please, your lordship?
Yes.
The appellant was facing his trial for offense under section 363, 376(2)(n of IPC, reviewed with section 6 POCSO Act and section 3 assisted
Is
minor.
there?
Conviction only offense under section 376(2)(n minor.
Oxford is not there.
No, my lord. My lord, the present applicant is custody, my lord, 6 years, 5 months, 8 days, my lord. And here in this case, my lord, I have filed an IA for interim bail, my lord, for his health issue, my lord.
Thank you. Take it from notice for the- and we will call for the court. Yes. Okay. Yes.
Item 8.
8.
Your Lordship, conviction under section 376(1) of IPC. Appeal IA filed for condonation of delay of 33 days and stay of realization of fine.
Okay. Same karo. What is the offense you say?
376(1), 450, 323, 506.
Notice for the same. Stay realization for the receipt of the TCR
It shall be
on
called.
services. Effective. Yes.
Obliged.
Item 9.
Yes. Yes. What's the offense?
Offense 126(2), 118(1), 118(2), 109.
Okay. Notice for you and stay realization in the notice for the application for the bail. Receipt after the TCR receipt. Yes. Yes. Next.
Item 10.
Father of the petitioner faced a prosecution under section 13 by the Vigilance Department. During the pendency of that proceeding,
It will be passed over by Lord Mr. Das in the way.
So it's for admission only. Yes.
during the pendency of that proceeding, properties were confiscated. I preferred appeal. During the pendency of the appeal, this honorable court directed to furnish a bank guarantee of 10 lakhs in order to protect the property so that properties may not be sold.
Yes.
Now, in the meantime, my lord, the father died. So the criminal prosecution abated. By virtue of that abatement, the legal heir filed an application before the confiscating officer seeking release. He refused to release that. Your lordship delivered a judgment. This is the judgment, my lord. And by virtue of the entire properties have been released in my favor. This your lordship judgment. Because he refused to enter an application.
I'll issue notice, let us.
My lord, no, I am now seeking a refund of that 10 lakhs because property.
Okay, I'll list it immediately after.
Sir.
I'll issue notice. You may be covered by this judgment.
Sir.
I'll issue notice. I'll list everything. I'll give a date. Huh? I'm just issuing notice.
Let an extra copy.
Give a copy of the judgment also. And
An extra copy
okay,
may be
let it come on. Let it come on 27th.
Sir.
27th. Huh?
Sir.
Simply issue notice. It can be disposed of. Why not?
Yes.
If it is covered,
Judgment covered judgment. No. He was saying that Mr. Das was saying that Supreme Court judgment has come in the meantime.
Maybe.
So you will cite the same.
Okay. 27th.
No, I'll give an extra copy.
Yes.
On which 28.
28th of this month.
Yes.
Issue notice. Reach the matter on 28th. Oh, just give the citation. The means that the case of the affiliate is covered by the judgment of this court reported in so.
2025, volume 2 OLR, page 48.
Okay. Covered by this judgment. Yes, next.
Item 11.
848. The co-appellant's appeal has already been admitted by your lordship on 29/7. This appellant is one of the co-appellants.
Okay, give the particulars.
453. CRLA 453.
453. Yeah? Tag with that.
29/7.
Admit करके take करो. ठीक. And stay realization कर दो.
So it may be tagged with that 453.
Yes. Okay. Yes. Tag with. Yes.
Item 12.
Conviction under section 74, 302, 302.
Sorry?
333.
Sorry?
74, 302, and 333. After being the 2 years in the offenses under section.
What is equivalent provision?
Provision, my lord.
3030, 379.
379, 303, 302, 3032, and 333, and 74.
Okay, admit for stay realization of the fine and notice on the application to be issued after the TCR is received. Yes. Next.
There is a conditional bail, my lord, before the court below.
Sorry,
There is a conditional bail was granted at the time of judgment.
where is that order?
My lord, order annexed 2,
Annexure
2, madam.
2.
Page 14, madam.
For 59.
14, page 14.
This is item number. कितने?
He's after the order.
12. Annexure 2 you are relying
Yes.
upon. Okay. What is this?
Page 14, he shall obtain the order of appellate court under session number within 1 month.
Undergo 2 years.
My lord.
2 years from offense from years. 24 to 3 years. Totally
2 years and 3 years
2 years, 3 years.
concurrently.
Yes. What is that?
That bail,
Bail. Okay. 389 right now.
trial in bail.
While sentencing the appellant for the substantive sentence up to 3 years and so on so forth. Appeal is convicted and sentenced to so on so. By the order dated 25/3/2026, sentencing court suspended the sentence awarded to the appellant by exercising the power under section 389(3) for CRPC for the period of how much it was here? It was suspended up till the appeal is filed. Till the appeal is filed. Since the short sentence. And how much you have undergone so far?
Undergone, my lord, 2 months.
The appellant has already undergone about 2 months of sentence remain suspended. Pending the appeal. Accordingly, petitioners will be released on bail on certain conditions. Yes, next.
13.
Yes.
Pardon, my lord, item 11.
Why you have not opened the mouth? What is the sentence? What is the sentence about it?
409.
What is the sentence about it? Have you read the file? 2 years. You should have told. Yes, sir. Give me right now.
Vigilance.
Yes.
Yes. Sorry, you're ready.
On bail.
2 year sentence, he couldn't say anything. 11. Item 11.
Item 11, your lordship admitted.
Admitted, but you didn't say that 2 year sentence, it has to be suspended. Suspended. Yes.
The co-applicant has already been released on bail.
Anyway, he didn't say that. Yes, anyway. Okay.
And may I please 7 by your lordship.
Yes. Item?
May I please 13 matter.
13.
May I please lordship matter. One of the offenses is under postcode matter.
Notice. 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 Please state. Okay.
Let's state.
Admit for again. Yes.
State relation fine.
Yes.
The sorted may people because the victim has not supported matter.
We'll see. Yes.
Item 14. Obliged.
14 is a trap case, 3 years.
3 years. Admit for 3 years. Okay. And stay realization and suspend. Sentence suspend. Grant bail. 55. Yes.
Item 15.
Yes. What's the offense?
Convicted of one of the folks.
Pokso, not
One of the folks.
notice for Pokso. ठीक है. Pokso. Notice, admit and all. Yes. Next.
Item 15.
15. 16.
15.
15 gala.
15 hala 16. Yes.
16.
May I please, my lord?
Yes.
Lord, conviction under 325 IPC, my lord. 325 of IPC. 2 years conviction of simple imprisonment, my lord. After the petition.
How much you have undergone?
My lord, 248 days as disclosed in the judgment. Thereafter, he is still in custody, my lord.
240 days.
48 days. That is mentioned in the judgment,
Right.
and he is in
Okay,
custody.
let me bail relief. From the first page of the judgment, it appears that the petitioner has already undergone about 248 days. 248 days. After the judgment was the impugned judgment was pronounced on 30th of June 2023, the petitioner is taken into custody. He is still serving the custody. And what is the sentence?
Sentence 2 years, my lord.
Sentence
Lord, while he was UTP,
and accordingly, during the pendency of the appeal, this sentence shall remain suspended. Accordingly,
Lord, while he was UTP, he was in custody.
granted bail. You don't
My
need.
lord, your lordship mentioned that on the date of judgment, actually he
He's
was
already there in custody.
Yes, my lord.
Yeah, that's what I'm saying. UTP is 148.
248 days.
248 days, and thereafter he's in custody after the judgment was
My
pronounced.
lord.
That's what I read every time. Yes.
Item 17.
Item 17, IA's copies have not been served on me. Only appeal memo copy has been served.
Yes,
So
madam.
IA's may be considered after receipt of fees.
What is the sentence?
Sentence 4 years.
4 years,
4
ma'am.
years. You have not given the copies?
Today, sir.
Okay.
4 years. ma'am.
Let it be considered later on.
Realization of final state.
My lord, he was
IA is
during the
concerned.
course of trial, ma'am.
The IA is supplied to Mr. Das today. Hence, lease the IA on 25th. 25th.
Day after.
Earlier, little earlier. Oh, he's in custody. He's in custody.
No, yes, my lord.
He is in custody.
He is custody, ma'am.
Then 4 years you should have given the copy unnecessary.
Copy has not.
Okay, 4 year sentence in any case.
दे दीजिए.
Any case, 20th.
No, no.
20th. Pudi.
It is fixed.
20th. 20th.
Yes.
Yes, next.
18.
Your Lordship, my lord, both the appellants convicted on section 304 part 2 and sentenced to undergo RI for 10 years, my lord. Along with my lord 340, 323 and 341 IPC, my lord.
What is the substantive sentence?
10 years,
3
my
years.
lord. 10 years under
10
section 304 part 2, my lord.
Okay, 3 years.
Yes, ma'am. So far, the appellant number 1 is concerned, he has already spent inside custody more than 5 years, as indicated in input judgment, my lord. And
5 years.
conviction total period is 10 years. Appellant, as per the in view of input judgment, appellant number 1 has been languishing inside the jail custody 5 years, 10 months, and 20 days, my lord. I want to take this honorable court that that column period of detention undergone.
Let us call for the record 10 years sentence. We'll see.
Yes,
Call for the record. I'll do this.
Yes,
I'll
obliged.
Okay, I'll go to record. Realization of the fine stage, and insofar IA is concerned, we should notice. Lease the after the issue of the yes. Yes. Yes.
19.
5 years for 201. And absolutely, look, the present appellant has nothing to do with regard to.
How much you have undergone? Let us.
My lord, during trial, my lord, he was in custody from 11/4/2021 to 26/4/2021.
Then how much it is near about? Near about 3 years.
No. My lord,
24, 21.
Only if lord, 15 days, I think.
No. Just see. Nandu Rakesh. Rakesh Vaina.
No.
Which one? Which item?
I am for Amresh Rao.
Item number?
19.
19.
Okay, 19. Let us see the impugned order. You are for?
Lord Amresh Rao.
Okay, Amresh. Okay,
Start from page
Nandu remained for 3 years.
Only 201.
Yes, I understand. Nandu remains for 4 years and you remain for only about 15, 20 days. Yes.
And punishment has imposed 5 years. I have gone through the record. After going through the record, it is a very clear case of 209 against
let me issue notice and admit issue notice, realization of the fine state, and insofar as IA is concerned, issue notice, lease the matter on 28th. On 24th of August.
24th
of August. This month. Okay.
Let have called for the LCR.
I have called for this. Yes.
Item 20.
applicant has been
Scan copy of the record. Instead of calling for the record.
wrongly conviction ହେଇଯାଇଛି ଆକୁ
Huh?
ଆକୁ conviction ହବନି ସେ instead of ଶକ୍ତି ସେ ଆକୁ conviction କରିଦେଇଛି
We'll see, then let the record come.
record ଆସିଲେ ଜଣା ପଡିବ
Yes.
And then appellants have been convicted under
20, yeah?
304 part 2, my lord, for 6 years, my lord.
Okay.
And during my lord, trial, they are undergo custody for 3 months and
3 months only, no?
now they are in custody.
Notice for you, no? Realize, see, and I note for those, each it after the.
But I am serving a copy of the deposition.
Yes.
21.
May I please, my lord? My lordship may fix that.
I'll fix it, yes.
My lord, convicted under section 363 and 34 of IPC for 3 years and sentenced for 3 years and to pay fine of 5,000.
One of the offense is POCSO.
My lord, main
Foxo is there.
POCSO is there against the main accused person.
Whatever name.
Notice for those.
My lord,
After reviewing of the figure, please.
we are in, my lord, interim bail, my lord. We have not received
Where is the interim bail? On what ground?
but my lord, ground is that we are
At
not,
the time of judgment, they have granted bail.
yes,
Where is that order?
that
10
is
years,
there, my lord.
10 years is there.
3 years. We faced 3 years, my lord. And in that judgment, it has been shown.
We means who? How many of you are there? Three of
my lord.
Sudhanta Naik.
No, my lord. Sushant Naik, Manas Swai, and Manoranjan Das.
That's what I'm saying. Why are you saying no?
No, we 3 persons.
Whatever the court says, you have to tell no only.
No,
Even if it is in your favor.
no, my lord.
Oh, anyway, these 3 people were convicted for which offense you are saying?
363.
Let us see the
34 of
operating part of this.
363 and 34 of IPC.
Yes, let us see. But one of the offense is POCSO is there.
Notice
That
is
is there, my lord, against the.
Whatever, that I can't distinguish. Notice has to go. Yes, notice has to go. I can give you a date, definitely, on 25th. 25th.
Again, we will be arrested, my lord.
But POCSO is there unless you, sir, take out the notice
Against
yourself.
the main accused person.
Oh, I can't distinguish. Then I'll have to read the entire evidence and all. I don't know. A case may be against you also. Let the record come and you take out the notice.
Date will be fixed, my lord.
Take out the 24th, huh? Through IIC, huh? Through IIC as well as through the plan. You can also take it. Yes. Yes. next.
22.
22. The lordship may kindly have a glance. Page 71.
Yes. What do you want?
71 may kindly have a glance.
71. Delay.
No delay. The one of the punishment is arrive for life is there. Clause B.
Okay. And then it has to go to division bench.
That's why I want to draw your lordship.
71, huh?
Page 71, clause B.
Okay.
Apart from the other offenses that
Since
also page 72,
that one
that
of
is also there.
the for the offense under section 65(1), read with the section 49 of BNSS 2023, life imprisonment in Nevada. Therefore, the appeal has to be listed before a division bench. Accordingly, list the appeal. The registry is directed to take a step to meet the appeal before a proceed bench. Yes.
23.
23, huh?
23, 376 1, 20 years conviction.
Oh. Yes. I'll admit it and call for the admit it and call for the record. Scan copy of the record and if POCSO is there, no, na?
No, no, it's a 376.
What are the offenses?
376D.
ମୁଁ ଖାଲି ଗୋଟେ ସର୍ଟ ଇଏ ହଉଛି ତା ଯୋଉ ବୟଫ୍ରେଣ୍ଡ କୁ ଇଏ ହରିଲେ ଦି ଅଦର ମ୍ୟାନ୍ ହି ଇଜ ନଟ୍ ପାର୍ଟ
376D.
ଆଜ୍ଞା ମୁଁ କହୁନି ଏଇଥିରେ ଯେତେବେଳେ ବେଲ ଦେଲେ ରିଜନେବଲ କୋର୍ଟ ମୁଁ ଏଇଖିଣି ଆପଣ
I'll
ରେକର୍ଡଟା
call for the record. Let
ଆଜ୍ଞା
it be, let it come first.
ଏଥିରେ ବି
Both the
ଡେଲିନେଟ୍
matters call for the
କରିଛନ୍ତି
record and admit, call for the record and issue notice. That's all.
ଫାଇନଟା ଷ୍ଟେ ହେଇଯାଉ ବେଲଟା
Fine, that's it. Fine.
ଯେ ଗୋଟେ ଖାଲି ପ୍ରେ କରୁଛି ଗୋଟେ ଡେଟଟେ ଫିକ୍ସ ହଉ
I'll fix a date. I mean, immediately after the TCR is
because
received.
by the time the bail
What is the sentence?
sentence 20 years
20 years.
by the time the bail was granted by the Honorable Court during the course of the trial, the vetting was already.
How much you have undergone?
ମୁଁ ସେଠି 2 years near about because October 2021
Anyway, how much after judgment?
After ଏଇଟା judgment ପରେ your lordship judgment was pronounced on
Yes.
Judgment was
October.
pronounced on your lordship 25/6/2025. So another 1 year. That means 3 years.
3 years roughly.
3 years, and he is not
After immediate out. Yes. Release. Yes.
gratefully.
Okay.
And in fact, if your lordship can also reflect the name. She got license on Saturday.
Oh.
So today is Monday. So
Therefore I will delete your name.
assisted by.
No. I will write the name of that girl.
ಹಾಗೆ.
Don't write the name of senior counsel.
No, my lord, regret for
You are now. I am ignoring your presence.
And I told her that ମୁଁ ଯୋଉଠି ଆଜି କୋର୍ଟରେ first appear କରିବି, you will be with me and I'll ensure your
So
reflection.
therefore I am ignoring your presence. For today.
Yes. It's a pleasure for me.
Ignore his presence.
I too welcome her to the bar.
So he should not have appeared. In fact.
Financial consequences.
Because
ଅଧିକ ଆଶା ହେଲେ ଯାହା ହୁଏ ଆଜି ବେଲ ମୁଭ୍ କରିଦେବି ବୋଲି ଭାବିଥିଲି।
Yes. Yes.
24.
the 24 is one of the offense is under POCSO.
Yes, 24.
One of the offense that
POCSO. Okay.
20 years conviction.
Admit, issue notice, and stay realized. And 25?
25 also same.
Same. No problem. But there is no application for stay of realization of fine. Is there any fine? I'll engage it. But where is the realization?
After the engagement that comes to pay.
And the oral prayer I'll state. There is no oral prayer. Engage from the news. Okay. Yes.
26.
My lord, I'm for the petitioner. But so the last direction was to file objection by the prosecution.
Your lordship permits, my lord, may I indicate one thing, my lord. In this case, my lord, lordship can turn to the page 78 or lordship reports.
78 of the brief.
Reports.
Okay. 28. Yes.
Now, this is a case, this revision is directed against that orders, any charge notes.
Against charge.
Against charge.
Yes.
And in the meantime, your lordship, I did not repeat it. After the framing of charge, the trial begins, and in the 30 prosecution witness examined, and the next case is posted on 30/8/2026.
Why don't you bring this thing on record?
That's the reason.
That's what he said.
This is the developments, no?
You bring this.
Your lordship, I record my submission that I got the instruction from the concerned SP that 31 witnesses has been examined. I've got the letter also. I also print out that I will give it to the lordship with records. In the meantime, 31 PWs have been deposed. Out of 86 charge-sheeted witness.
86.
And four accused persons are there originally. One accused person died. So 3 are facing their trials now. The next date for
yes, Mr. Mahapatra, the trial is proceeding in expected pace.
Considerably. Proceeded considerably.
On that point, let me verify that. And second part, my lord, the last direction in 23 was to file an objection. It is here both the petitioner 1 and 2, the wife and mother of the main principal accused. And the wife is also a government employee. Her salary has not been taken into account.
Since there is no stay, you file an affidavit stating all this thing on record. Okay. I'll simply, Mr. Das, we have counsel for the resilience submits that the trial is proceeding at an expected.
My lord, item number 26.
And he will place on record the present status of the trial. Least the matter on least on 27th of August. 27th August. Yes.
My lord, item number 26. Mr. Manas Ranjan Khatwa is ill today. This case may be taken up.
Who is ill?
I'm for the petition.
He is appearing.
1 minute. 1 minute, Mr. Das. He's saying something. Wait. Yes.
Your senior is
yes, tell me.
My lord, I was sick. That is the reason it was informed to the party. So, but I managed to do it virtually.
No, the problem is you are not well.
No, the body language is different.
You are not well, still you are appearing. Your junior is saying that you are in hospital.
And body language is also different.
When a senior is appearing, you see his face, then you make. Even if instructor indirectly see the appearing. He's not well. He's appearing, he's arguing the matter.
Okay.
Yes. Presence of mind is required. Not that whatever he says that he'll come and say. Yes.
27.
My lord,
27, your lordship. I will be pardoned, your lordship. Mr. R.K. Mahapatra appearing for petition number 4 was supposed to be here. But,
Sorry?
Bring for Passover, your lordship.
Passover, okay.
May I suggest one thing, my lords? These both the matters, my lords. In fact, 3 accused persons, my lord. They are 1 accused person died, my lord. So 3 out of the 2 are before lordship. These 2 cases were for another previous bench, my lords, and 8 times the case was listed, my lords. And this was heard. And in fact, what I suggest, my lord, let him take time, my lord. We'll exchange the notes, my lord. Otherwise, it will take a lot of time. The courts. He'll just place the notes and that's
it is against what? It is
against an order of discharge, my lord.
What is the stage of the trial? Is there any stay operating?
my lord, stage there on filing adjournment application, the learned trial court will give adjourn, your lordship. That prediction is there.
If we can confine the submission with only the 2-3 pages notes, my lord, that will suffice, my lord. Otherwise, it will keep on arguing, but that is a lot of time will be consumed.
This revision is set for final issue. Let the counsel appearing for both the parties file a written note of submission confining to maximum 3 pages.
3 pages.
3 pages. Maximum 3 pages. Please the matter on 27th. 27th.
Order may be continued.
No,
There are a lot of hearings, nothing is
no interim orders. The only thing
Interim order is not the stay of further proceeding, your lordship.
No.
Because the proceeding is going on.
just the
On our
see the previous 5 days. Where is the order?
my lord, order is there, your lordship.
Just see previous 5 days. Immediately previous.
pursue the court.
Shall I read it for you?
My lord,
Since last 5-6 days, you have been taking time. Both are
no, lordship. Not a single day.
interim order show me, but that's all.
My lord, interim order is there, your lordship.
Where is that? Last 5-6 hearing.
Interim order is there.
Where is show me? I show me 5-6 hearing.
My lord, I have taken certified copy and also produced the same before the
What
trial.
will I do? The certificate copy. See the order here.
My lord.
22/7/2026 simply urgent. 14/7/26 simply urgent. 3/7/26 simply urgent. 24/6/26 urgent.
My lord, next case,
Where is the interim order?
yes, lordship, in connected case, stay order is there and jointly in both the cases that has been.
I can't say anything.
Yes, lordship, kindly see.
I'll pass it over ready. Argue. I'll dispose it up. Today, 3 o'clock come, I'll dispose it up.
After launch, it will be taken.
Yes. Come down. Get ready. I'll dispose it up. No question of interim order. Nothing. Get ready. The revisions will take 5 minutes.
Only 2 times rate has been taken, 3 times.
But I read out how many days?
There was some difficulty.
About 6 days.
Father of the architect passed away in the meantime.
Whatever, I don't know what is the reason, but it is
giving time.
against discharge petition. Just imagine, against a discharge, rejection of a discharge. 6 times you have taken. I'll tell
My
you how
lord,
many.
6 times they have taken time because the father.
I don't know who has taken it.
Conducted
Nothing
was
is
expired, your lordship.
And this is 9th hearing.
Yes,
This is,
lordship.
today is 10th hearing.
My lord, kindly see, my lord, kindly ask my friend whether I have taken time.
Yes, no,
So kindly, you know,
How do I know? I have to see
the eyewitness, he is the eyewitness to.
I have to see the orders only. I don't know who has requested.
He is the eyewitness, whether I have taken time or not.
ठीक है सुन तो 3 पेज नोट्स कैसे लागियो
दे देबो
Therefore, I'm fixing a date.
Yes, lordship.
Yes. Yes, next.
My lord, tickets are full. Pardons in item 23. I should have given better assistance. ଦେଇଛନ୍ତି ଦେଖନ୍ତୁ ଲିଷ୍ଟ ଆଇଗଲ ଅଛି
What do you want?
ସେଥିରେ ଦିଟା ଅପିଲ ଅଛି ଗୋଟେ ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ଆପଣ ତାକୁ ଏନଗେଜ କରିବେ ଡିଲେ କଣ୍ଡୋନେସନ
That I know.
ଯୋଉଟା ଫାର୍ଷ୍ଟ ଆଇଟମଟା
Second item you appeared.
ସେକେଣ୍ଡ ଆଇଟମଟା ଆଡମିଟ ହେଇଯାଇଛି 2025 ରେ ଏଲସିଆର ଆସିଯାଇଛି ଆଉ ଦିନକୁ ରଖନ୍ତୁ ଖାଲି ବେଲ ଟା କନସିଡର
I'll just check it up.
Okay.
Okay.
ତାନେ already there
देखिए यदि LCR है तो you will do.
next week पास विचार
Okay.
obliged
Yes.
अब खास करे कि ओटे एंगेज है
Yes.
right
Yes.
grateful
28.
Your my lord, that release of
Lordship permits, my lord. Lordship, 1 minute, lords. Lordship, in this case, I'm ready, my lord. Since I'm going to place one judgment, my lord, can it pass it over, my lord?
Pass it over. Pass it.
So the other matter, short matter,
Okay,
can
so, no. Yes.
Item 30.
29.
29, 29?
Adjourn.
Arjun.
Item 30, my lord.
What is 30?
132
What is this?
delays.
State and file, huh?
Days delay, my lord. IA for condemnation of delay, my lord.
How much delay?
132 days, my lord.
What is the reason you given?
The reason from para 2 to 5 categorically stated everything, my lord. Judgment delivered on 12/5/2025. Thereafter, Superintendent of Police was sent a letter and submitted by his letter 21/6/2025 before the learned PP Sundargarh for submission of his opinion, my lord. Thereafter, PP submitted his opinion on 25/6/2025.
What is the offense?
Offense, my lord. Offense under section.
NDPS.
Yes, my lord. NDPS. Total 3,157 kg of ganja, my lord.
What are the ground for challenging? It is an acquittal order. Why should the court will interfere? State appeal means you should be ready. I'll not admit like this. As it is delay.
Yes, my lord.
As an against an acquittal. Where is the perversity?
Let it come next week. Because I was prepared for only condemnation.
No, it's not routine. Yes. Against acquittal, I'll not admit. It will remain pending for 20 years. Thereafter, again, it has to dispose of. You satisfy me. Is there any perversity in acquittal order?
Yes, my lord.
Then only I'll do it. Otherwise, on the ground of delay, I'll dismiss it and finish it. Ultimately, after 20 years also, the same thing is going to happen. Why not today? Get ready. Get ready.
Next week.
And come, if you have a case, just
Yes.
satisfy me.
Yes, ma'am.
If you have a prima facie case, I'll definitely admit.
Yes.
But otherwise, we'll see. On the ground of delay, delay is not also properly explained. Files kept on moving from here and there. That's the explanation.
Let's keep it next week.
Please sit on 18th. No. Let it be on 17th. 17th, huh? Okay. Prepare a short note.
Yes.
Yes. Yes.
51.
Yes. What modification, sir?
No, my lord, I am for the petitioner. The OPO has filed for modification of order, my lord.
What modification you want?
I don't know, my lord, because the copy of that IA has not been served on me.
Is to modify the order also by giving direction to the drawing disbursing authority of the petitioner's institution principal to deposit the maintenance amount by deducting the same from the salary of the petitioner. Who is there?
May I pray your lordship, my lord, I have not received the copy of that IA. So I am unable to submit, my lord, why the modification is required. Order dated 1811.
Are you appearing before the trial court?
My lord.
Are you appearing or not?
My lord. Okay. No, I am not appearing local lawyer.
Whatever you means your client is appearing, paying maintenance.
My lord.
Shall I record the statement, your statement, that you are appearing for the trial court and paying the regular maintenance?
My lord, let it come next week. I'll take
Then
it.
why next week? You tell me. Is your application? It seems the application is 2019 order is asking for modification. It is arising out of 125 proceeding.
My lord,
You simply tell you are appearing for husband,
My lord.
isn't it?
My lord.
I'll record your statement and dispose it up. Right down. What is the name?
My lord, but the copy has not been served on me.
Right down. I'll just the petitioner husband and move the revision. Move the criminal miscellaneous petition seeking a recall of the order dated 13/5/2019 passed by Lieutenant STJ Manandpur in CMC number 6/4/2019 issuing the NBW. This court by order dated 18/11/2019 recall the order of NBW. Subject to the petitioner appearing before the trial court and making good the maintenance of every month. The wife has now moved this application seeking modification of the order dated 18/11/2019, seeking a direction to the authority, direction to the principal cum secretary of Jadespur High School, Tolkani, Jajpur, to deduct the maintenance amount from the salary of the petitioner, and this was the same to that. This application was filed way back in 20th August 2024. None appears for the respondent wife. The land council appearing for the petitioner submits submits an instruction that the petitioner husband has been making the maintenance amount good every month to the opposite party, only the wife. Taking note of the statement made by legal counsel for the petitioner, I think the petitioner, the application at this stage needs to be disposed of. Accordingly, no interference is called for. The application is disposed of. Yes. Next.
32.
None appears. Okay. What is this?
Extension.
Huh?
Extension plan.
Extension of line. Last time also non right. So the application was called for hearing on 2/7/2026. None had appeared. Therefore, in the interest of justice, matter is adjourned to today. Even today, none appeared for the petition. Hence, the application stands dismissed. Yes. Next.
33.
This matter was before your lordships on last occasion by last week.
Sorry?
The learned district judge has submitted a report regarding disposal of 33 bags of ganja malas. Two similar matters were also there before your lordships last occasion.
Yes. Turnover order for the disposal of ganja. It occurred also in metro. Okay. You don't have any objection? I am recording it. Yes.
34.
Yes. 34.
But the stamp reporter says the appeal may lie to the session judge, not to the High Court, because the sentence was passed by the assistant session judge in the 376. My primary objection is mine that the rate 370 trial exclusive by the session judge. Unless until that was.
But assistant session judge has passed the order, then.
Unless until the session judge empower him to pass the order, then appeal to the High Court also, because he has passed order as a session.
So therefore you are withdrawing it and filing it. Will you withdraw it and file it?
No, well, because the order was passed by the assistant session judge. Without
No, that's what I'm, assistant session judge is not in the cadre of session judge. So the appeal lies to session judge.
Well,
that is the objection.
My submission. Once the order was passed by the assistant session as a session judge.
Where is that as a session?
But unless until that power, as per 28(3), if session judge pass order, if authorized by law, unless until he authorized by law to pass and try a 376 matter, he can't pass orders. I mean, if he passed matter, then appeal to the High Court.
So therefore you have to go to sessions court for filing appeal.
Because I filed rightly here. Because
No.
if assistant pass an order as a session judge, my lord, otherwise he can try.
Where is that order?
Your lordship kindly.
Where is that order? As session judge.
Your lordship kindly see before amendment 2009 amendment. 9 imprisonment for
1
life.
minute. 1 minute. What are you reading? Which provision you are reading?
That is KRPC matter that noted that what case trial by what court.
Well, show me something.
Your lordship kindly.
Get a copy, pass over. Get a copy, pass over. Yes.
35.
There's a case on NDPS Act, madam.
Sorry?
NDPS Act. Previously.
Sorry, after. Yes, sir. After.
Yes, it's pass.
Previously, he is on bail, 3 months bail, madam. Till bail. He is on bail. And rightly he has surrendered, madam, in time. On 10/11/2025, I have given interim bail of 3 months. I have surrendered rightly. Woman advocate also given the surrender letter on 19/9/25. Which is
Why this application? Why this matter is listed today?
My lord, it is listed furtherwards. Because by hearing not pursued, or bail be given of more than 8 years he has been.
What is the sentence about it?
15 years.
15 years.
So 8 years only. List it. 2021. List it for hearing. I'll list it for hearing. We'll see.
When was date? Can I get a date?
I'll give a date. Wait.
Obliged, madam.
List it for hearing. Yes.
36.
In this case, sentence is 20 years. In 6 of a POCSO Act, already served the sentence for more than 11 years, 12 years already. He may be released. 12 years, a young boy.
You have moved a fresh application for bail? Where is the bail application?
The miscase, your lordship, I have filed.
Which one?
1241 of 21.
21.
21.
This application is not dealt with so far.
No. He is in custody. He is serving the sentence there. Well,
on this application, no order is passed so far.
No order has been.
Okay. 1241 notice for one. One of the offenses POCSO Act. Serve the through IIC and release the matter after serving. Yes. I have to issue notice. POCSO is there. Yes.
Yes.
37.
Yes, served the sentence.
Let us see the once he comes, then I'll hear. More than half of the sentence you have already undergone. Yes. Therefore,
12 years running.
I have issued notice and immediately after service it will be listed. Yes.
A date may be fixed.
I'll fix a date. Look into it. Fix a date. I'll fix a date.
Okay.
Yes.
37.
May I please? The appellant convicted under section 21C of the NDPS Act matter.
My lord, 10-year conviction already near about 6 years in custody, my lord. This annual could have granted Indian bail for 4 months, my lord, and release surrender in time, my lord.
Call for the custody certificate and all three.
I got bail, my
You
lord.
get the custody certificate
Custody.
and antecedent and all,
Yes.
huh?
Antecedent already
Where is that?
it done. Order dated
Where is the custody certificate? Jail conduct.
posted, sir.
Jail conduct?
Yes.
You have jail conduct?
And surrender certificate also. Surrender certificate.
Okay. 8/12/2025, antecedent, call for the antecedent.
What are you showing? It's just surrender certificate. For what? Lease the matter.
Antecedent is call for
Lease the
matter.
matter on 25th. Like 24th. Yes.
Call for already surrender certificate is
I know, madam. I am calling for the custody certificate, jail conduct, and your antecedent.
antecedent already.
Let him verify and give it.
The order dated 18/12/2025.
Where is your custody certificate? You are going, coming, and all these things. How will I calculate it? Here. Otherwise, give me calculation. How many times you have gone out and how many times you have surrendered? Let that exercise be done by them. I'll get a certificate. That's what I'm giving a date on 24. He also needs some time. He'll ask for the instruction. Wait, yes. 38.
May I please, Your Lord? Also, my power may be accepted. I have filed the NOC from Lord and Senior Advocate.
Your senior is sitting quietly.
My lord.
Yes.
The present
All. All except. Yes.
May I place the interim application for bail?
Where's the sentence?
Sentence is 366 of IPC for 10 years and 30,000 rupees fine.
What is the undergone period?
Undergone period is
POXO is
3 months. POSCO has been deleted.
Notice.
My lord, POSCO has been deleted from
Let us see.
High Court. 6 of POSCO has been deleted.
You have been acquitted.
Yes, in POSCO offense I have been acquitted. Only 366 and 3762N and 32 VA of SC/ST PA Act मते conviction है.
ACST is there.
STC.
मतलब notice
Notice also right.
Notice ACST होती. ACST is one of the offenses.
You are representing for
Notice. In the meantime, you are appearing. I appeal already appeal. Don't show it.
Lordship. Notice has already been ordered. 28/11/20.
What is the custody period you said?
3 years, 10 months.
Okay. Out of 10 years. Let's find the custody certificate and the jail conduct as well as the antecedent. Yes. Let him get it. Yes, next.
39.
Yes. Yes.
Item 39.
What is that? No, nothing. After September 1st week, they T-shirt 3rd of September. 3rd September. Yes.
40.
May I please?
Yes, sir.
This is the subsequent bail application.
Sorry?
This is the subsequent bail application.
Mhm.
And the honorable coordinator bench find that if the case will not be disposed within paper book is not ready and not complete hearing, it will be part petitioner liberty to renew prayer. Another case is that 7 years conviction, POXO and other 376 offenses there.
Yeah, I'll have to issue
My
notice.
lord, so far as POXO, people since if your lordship will examine the statement of the victim and the impugned judgment, the date of birth is there is no conclusive
I'll have to issue
evidence.
notice. Bail application, I'll have to issue notice. POXO is there. I'll issue notice and give.
No notice already issued, my lord.
Where is that? Show me.
And it's,
And which date notice was issued?
when the case was admitted.
Which date? Refer to the proceeding.
Notice issue ହେଇଥିଲା ସେ ଆସିନାହିଁ.
Show me the order, sir.
Order sheet ରେ ସେଟା order sheet
Nothing.
ସବୁ ସରି ଯାଇଥିଲା. ନୋଟିସ ଇସ୍ୟୁ ହେଇଥିଲା ଭାଇ.
ଦେଖो order ଦେଖୁନାହାନ୍ତି ଆପଣ?
ଦେଖିବି ନହେଲେ ନେକ୍ସଟ ଅପେଜନ କାରଣ ମୁଁ ଆଣିନି ମୋ ପାଖରେ ନାହିଁ ସେଟା.
ତିନିଟା order ଅଛି କାଢିକି ଦେଖନ୍ତୁ ଆଜ୍ଞା. ବନିଆ.
ମୁଁ ଏଇଟା ମୋର ନେଇ ବାହାର କରିଦେବି. ହେଇଥିଲା ଅର୍ଡର ନୋଟିସ ଇସ୍ୟୁ ହେଇଥିଲା ଯୋଉ ସେ ଆପିୟର କରିନା.
Issue notice to the and in the meantime, to IAS. In the meantime, the state to obtain the certificate, antecedent, and the jail conduct, lease the matter after the service of notice. Yes.
My notice already issue ହେଇଥିଲା. If your lordship,
I've seen it.
I will verify and form it in next occasion.
None.
And so far antecedent.
Don't worry. I have done your job. Don't worry. Wait.
It's like
Yes. Next.
41. Lordship,
Giving a date. I'm giving a date. Yes.
more than 3 years already completed.
Yes. Yes.
My lord, earlier notice was issued and the victim also filed an objection to the bail application.
Yes. The sentence?
The appellant was convicted under section 6 of the Code Act and sentenced to undergo RI for 20 years.
Period of custody.
Period of custody.
I'll call for this custody jail conduct and custody jail conduct and
more than 3 years, 8 months, nearly 4 years.
I'll call for that, huh? Jail conduct
It's 5 years.
and you get these 3 certificates. Yes. 43.
42. 42, my lord.
Somebody mentioned it, sir.
42, my lord. I have filed for interim bail, my lord.
I don't know. Somebody mentioned it.
But they have filed a IA for the interim bill regarding they have given that his father is dead, man. Was
Who?
that? But his father was.
Then who has mentioned it? 42.
Yes, 42, my lordship. The instruction also I have received from the judge.
Who has mentioned it then? 42 mentioned something? 42 weekly, 44 weekly list.
Weekly, it's a second weekly record.
Yes, Mr. Mahapatra, what do you say?
29 तक होते 42
Sorry, my lord, 42. I have filed a IA on the ground that the elder father of the petitioner expired and he has to be released on interim bail to perform this Kriya and to.
His elder father was dead, not his father.
That's a Naresh Naik, father of Raja Naik, Lakshman Naik, the elder. And see, you have given a wrong information.
Yeah.
Wrong information.
You don't even know your father's name. See the report. Your father is one Mr. Naresh Naik.
Hey, I have given elder father, na? I have given.
Wait, in the application, where you state that?
My lord, I have mentioned that my elder father has expired.
Yes, para 3, just see. Para 3.
I am joint family.
Your lordship directed me, I have taken the instruction.
No, para 3 is written, elder father.
Yes, my lord.
IA copy they have not served the IA copy, but as per your lordship direction, I have asked to the.
Okay.
Yes.
Verify just, I'll just give a copy. I'll take it up day after tomorrow. When he died?
Copy I have already sought, my lord.
But he says she doesn't have the copy. Somehow he got the information.
Yeah.
It's written elder father. Though in the handwritten, but somehow it is written.
My lordship,
Just
an interim.
give a copy. I'll take it up. Take it up. Give it tomorrow. Let me do it tomorrow. Huh?
Yes.
Tomorrow. You give a copy immediately. I'll take it up tomorrow. Yes.
42.
Yes. 43.
My lordship is
I am the petitioner.
That's the you sought for an adjournment.
My lord.
Mr. Mahapatra is people.
No. I am the petitioner and I am filed Vakalatnama and prisoner petition.
Raja Naik. Your client is Raja Naik?
Yes, ma'am.
Huh?
Yes.
Mr. Mahapatra is appearing. Whose Vakalatnama is that? Just see, check it up. That's what. Where is the Vakalatnama?
My lord, file prisoner petitioner.
Mr. Mahapatra is appearing for whom?
For Rajan,
I don't know.
for the petition.
He is saying he is appearing for. Vakalatnama is Mr. Mahapatra is not filed the Vakalatnama. 42, no? 42. Just check it up tomorrow. I'll take it up. His elder father has died. Some application. You have moved the application.
No.
Who has moved the application?
Mr.
Do you have any information that the elder father of the convict has died? Do you have any information?
No, man.
And who has then who has moved the application?
I don't know.
What is this going on? I don't understand. Just see from the file what exactly happened. I'll take it up tomorrow. If his elder father has died, they want interim bail. Either it has to be given or it has to be rejected. Just check it up. Check it up and tell me. I'm taking up tomorrow. Okay. Yes. 43.
I'm a 43, my lord. May it please your lordship.
Yes.
My lord, petitioner, the appellant, has been convicted under section 4.
Ganesh.
Section 4 of the POCSO Act, my lords. And my lords, under 376(1). My lords,
What do you want now? Bail.
Bail.
Notice has to go to.
Notice has already gone.
See the service. Yes. In the meantime, you tell me what is the case. How much you have undergone?
3 years, my lords, out of 10 years.
Out of 10 years.
3.5 years, and it is an admitted position that
yes,
it's an admitted position that they had eloped, and further, my lord, elopement, of course, my lord, with a minor child, it will not amount to anything much, my lord. But the further cases, the girl herself says, by her own calculation, she will be more than 18, and
service is complete. The service is not affected, sir.
17/7/2025.
You take out notice.
my lords, if your lordship wants, my lords, we can give a fresh notice, or the state can, because what is happening, my lords,
Through
they are not-
IIC.
Through IIC.
Sir, through IIC. Notice is not.
In 17
If notice the informant of the complainant, a victim, to be served through the IIC so and release the matter immediately.
Yes,
Taking
the
out notice through IIC.
problem is, my lord, what has happened, she has got married thereafter, and she is living.
If she doesn't come, then I will engage someone. And,
let the IIC take steps.
yes. With in that format, okay?
Yes.
Yes.
Obliged.
44.
The petitioner has been convicted under section 8 and 12 of POCSO Act and sentenced to undergo for 4 years, my lord. Out of 4 years, after conviction, my lord, he is in custody for a period of 2 years. And during trial, 2 months, my lord. 2 years, 2 months, royal and 4 years.
Notice has been issued?
Notice, my lord, issued, my lord.
Sufficient.
Sufficient?
Yes.
Anybody has filed Vakalat now?
No.
Hmm? Where from you got sufficient notice? Let us see. Where is the office?
Staying outside.
Just see. When the notice was issued? Notice was issued when? It was the notice.
2010.
So we have noticed, okay. Notice for Sure, okay. Persons to the ordinary date 28/10/2024. Notice on the informant of the victim already been served to the IIC. Which IIC? This is IIC? IIC Punta, yes. IIC Punta PS on 8/12/2024. The proof of service is placed on record. Photocopy reference. However, none has appeared for the victims pursuant to the issuance of notice. Therefore, I engage करो किसको how to engage you. देखो just see some girl. I'm engaging some some give it to some girl because it's a Foxo case. Give it to some girl who is there. Yes, I'm engaging a list it. Okay, list it on. Let it be on 21st. 21st. Okay. 21st. August. 45. Give it to someone immediately so that take the copy. Anybody is there?
My lord.
Yes.
I am for 9/40/2024.
45. Yes.
My lord, I am for 9/40/2024. Paperwork is not received.
Okay. This is for final disposal.
That 3 appeals are there. All other co-appellants in second and third sub-item are on bail manner.
That is Jayanti Sahu.
Jayanti Sahu
And
Gobind
Gobind.
They are on bail. So far as the 2 appellants in first criminal appeal, except appellant number 1, the other second appellant is also on bail manner. Appellant number 1 in first appeal has been convicted for 3762I and 4 of POCSO for 10 years minor. And in the meantime, he has served already 2 years and 5 months in custody. What I humbly nothing a call for the custody certificate thereafter.
Okay, so far as in the first appeal, counsel for the petitioner submits except the appellant number 1, all other co-accused persons have already been admitted to bail. The appellant number 1 has already undergone roughly about
Near about 2 years and half.
2.5 years. Sentenced out of 10 years. Okay, 10 years. Call for the custody certificate. Yes. Yes. 46.
For 10 years under section 20B2B of NDPS Act, and he has undergone for a period of near about 5 years in custody.
Out of 10?
10 years.
I'll call for the custody. Yes. 47.
47 years, 10 years conviction, out of 10 years, 8 years, 8 months impact of law.
Yes, madam. 8 years, 8 months. 24 appeal. Not to be heard in near future.
To check.
Confirm the sentence period.
Yes.
Confirm the sentence period. Where from I'll get it?
Let's see.
Then I'll get a custody certificate and give a shorter date.
From the date of arrest, he is in custody. Let's see, kindly say, running page
Let us see the
24.
impugn judgment first.
Running page 24.
You have Babu, huh? What is your name? Babu. Isn't it?
Vibhuja.
Vivu Delhi.
Vibhuja.
9/12/2017 to
till date
30th August 2024. When the judgment was passed.
That is on that.
Throughout trial, he was on custody. And yes, madam, what do you say?
8 years, 3 months, my lordship, he is in custody. 8
sorry?
years, 3 months.
8 years, 3 months. Any antecedent?
That part I have to take instruction, my lordship.
And I am giving a very short date because
Yes.
8 years he has gone. I'll put it on 14th. 14th.
Today also. For today.
14th. You tell me antecedents only. That's
Yes, ma'am. Yes.
I'll have to grant bail. 8 years, more than 8 years. Yes. 14th, huh?
Yes, my lord.
Yes.
48. 8 years.
No, from the front page of the implementation. It appears that the appellant has already undergone more than 8 years of incarceration out of substantive sentence for 10 years. How was the incident and bail fund after the petition is not known since the state possibly directed to obtain. Yes, please put it. Yes.
48. Convicted under Section 6 of the POCSO Act, sentenced to undergo RI for 20 years. The appellant was on bail during trial, and thereafter he is in custody since.
A notice has been issued. Notice has been issued.
Lordship, I am appearing.
You are appearing.
Appearing.
Yes.
3 years in custody, 2 years after the judgment, my lord, and during the trial 1 year, my lord.
Yes.
The medical report not supported the prosecution case, and as it reveals, after 4 years of the occurrence, FIR has been lodged, and there are visiting terms 4 years. Victim continuing visiting 4 years to the house of the appellant, and thereafter FIR has been lodged. And subsequently, medical report of the doctor has been examined PW 7.
Let us see the victim's
Victim PW 1.
PW
1.
1. Okay. Yes. What was the age of the girl? 17.
11 years.
Then
She was reading in standard 8.
yes, the 17 years coach is as for the 18 years is as it equals the evidence is about 18 years, and in the year 2018 I was reading in class 8. I was visiting frequently to the house of the prisoner who is my Amini Pradhan, who is my friend, for the purpose of studying together.
But this was the continuous act.
Yes.
Continuing for 4 years as it reveals.
For 4 years.
Medical report.
Kindly have a glance to the PW2 and PW9. And PW has.
But FIR registered after 4 years.
Because that reason also taken by the load from
After 4 years on 19/11/22 FIR was lodged. And medical report PW 7 is a doctor. Opened, there is no physical injury on our private part, there is no sign symptoms. Pregnancy test was found negative. PW 7 men.
His boy is 26 years.
Considering that asset
Sorry?
Your Lordship, the appellant.
You also please, you are appearing for victim, na? Please read in that line, na? Okay.
Your Lordship, the appellant has been convicted under Section 6 of the POCSO and sentenced to undergo 10 years of arrest. Your Lordship, IA number 1844 of 2026 is pending for bail. Your Lordship, notice may be issued.
Okay. So notice and release the matter through IAC, release the bail application after the server of notice. Yes. Yes.
50 minutes, please, Your Lordship. So President Appellant convicts about to 80 years old, around 80 years old. He has been convicted in 376 to L and J. Convict 376 to L and J. And the sentence is 10 years. And out of 10 years, he has been in custody for around 3 years.
He's still continuing in custody. Yes, madam, what do you say?
And she has given the statement, and also she was pregnant, my Lordship. That is that. Even if the DNA test also filed in my Lordship, but the doctor has strictly given that no accused is also
Capable.
Accused is also?
capable of sexual intercourse, and also he has given that DNA test proof.
What is the offense?
20B to C.
Sentence is 10 years, huh?
10 years. Kind of.
Oh, same. Call for the custody certificate and all. I'll give it 8. Yes. Yes.
52. 52, my lord, on the last occasion, Your Lordship had directed the state to take instruction. My mother is not well. I'm only seeking for a 1 month bail.
Got a report? Report is there?
Yes, Your Honor.
Yes. She has undergone a heart surgery and another surgery schedule and all. I will grant. How much you are seeking now?
1 month only.
1 month. Okay. The convict appellant is seeking interim bail for 1 month on the ground that his mother is terminally ill and underwent procedure, medical procedure. By order dated 27/11/2026, a report was sought from the concerned police station. The IIC Model PS Khurda has placed on record a report dated 2/8/2026, which means regarding to the report, and the government made in the application, the same is allowed. Petitioner shall be released for 1 month. Yes. 53.
Petitioner was convicted on section 10 of the POCSO and sentenced to undergo RI for 6 years. Without going to the merit of the case, my lord,
Notice,
he has already
notice has gone?
Yes, sir, notice, sir.
Sir, already sir?
Yes, sir.
I'll have to appoint someone.
One counts.
If nobody.
Council filed Wakalatnama. That
Already filed? Okay.
Yes.
Okay. Is there?
Basanta Kumar Naik appeared.
Sorry?
Basanta Kumar Naik appeared.
Okay.
His name.
He has already undergone more than half of.
Can I just pass over because somebody has filed Wakalatnama? He may come for victim. I will just pass it over. I'll just pass it. May come, somebody will come. Yes. Yes. Next. Or good take or
54.
54.
My lord is praying for an Passover, my lord. My senior will appear in this matter.
Sorry?
Praying for an Passover.
Passover. 55.
55.
Right, my lord. That's notice me. Not send my lord.
Notice to?
Notice here.
Service. Notice was issued already.
notice not solved.
Notice was issued on 29/7/25.
Yes, my
Just check it up. Service.
lord. In this case, the appellant was on bail during trial.
Let us see the service position first.
Sir.
Service is there? Service is not affected. Although the notice to the respondent number 2 was issued on 29/7/2025, but the service has not been effective. Therefore, last opportunity is limited to the state council to serve to the respondent number 2 through IAC. Through IAC also. I'll give it least the matter on 25th. Then just come through with the 5 minutes.
Question is for password.
Password.
Password. Let it go next to and to the OPID.
My lord, my learned senior Mr. Ponda will assist you in this case. Mr. Devas.
Any day next week.
He's seeking.
Password.
But he's seeking adjournment. He's not ready, then in any case it will be adjourned.
Then stay should continue because the
Okay, it's all right. Next week, hopefully, material video.
my interim
Interim order. Is there an interim order? Is there?
in the last date the court had ordered that upon us filing a
I don't know. 56, na? Let
Yeah.
us see the order, last order.
If already there, then
It's already there, then it will be cut.
My lord, it was a order that if we file a petition for time, then the court would grant.
Yes, there is an order. There is. Yes, it will continue. Okay.
57.
Next week, Tale. Then you give it on 28, huh? 28. Yes, 57.
57 millard, there are 4 offense millard. And there are 5 persons. And here offense is 20B2C, 10-year punishment. And the entire millard, the conviction is based on only
What's the period undergone?
Period millard, 2 year, 2 months.
2 years,
2 year, 2 months. And here millard, total millard, the conviction is based on 3 witnesses. Out of 3, 1 is the seizure witness, that is non-compliance of section 100, subsection 4 of section 100 of CRPC, because there must be 2 independent witnesses. So that 1 independent witness has turned hostile, that is PW3. And the remaining witnesses are 2, 1 constable and the millard inspector excise. And the informant is himself the IO Miller. So there is so many lacunae.
What about your antecedents?
No antecedent. 5 persons.
Report. Reach it. Get a report. Antecedents. Yes. And just see whether section 100 this thing is complied or not.
Yes.
The 2 witnesses are cited. One is that's the different story.
No, 2 witnesses are not there. There is requirement for citing 2 independent witnesses, but here there is 1 witness.
No, they might have cited, but examined 1. That's a different story.
Not cited. Not cited.
Not even cited.
Not even cited.
Yes.
He is hostile also. And that is the 2 vehicles.
That is usual story. The seizure witness is always hostile. Never supports. That's the usual story.
And the informant is himself the IO. There is
Then you have to show whether you are prejudiced or not.
Yes.
Those things. We'll see.
Yes.
Date. Huh? Yes.
18.
Yes. 58.
It is the victim.
The petitioner has been convicted on section 363 and 376 2 and IPC and sentenced to undergo RI for 10 years. During trial, he was on bail, and after conviction, he is in custody. And no criminal antecedent.
POCSO is also there.
POCSO. Notice is sufficient, madam.
No,
But
notice has already been issued. Let us see.
Notice sufficient by order dated 19/9/25. Notice was sufficient, and copies of
Yes, see.
divorce are also served on state.
Anybody has filed vocal number? Nobody is entered. This
19/9/25, what is it?
nobody has entered appearance. I'll engage someone.
Madam, pardon.
I'll engage someone. Amicus curiae for the victim.
Victim.
Since notice has been issued and nobody has entered appearance, despite this, none has entered appearance for victim. Shown for the amicus curiae to assist, and I list it on 25th.
Madam, pardon.
25th August, yes.
Sort of 17, 18. 17 or 18.
No, 25th.
Madam, pardon. Another thing, April, madam. In the meantime, state be directed to call for the report regarding contract certificate and cost certificate. Contract and cost certificate.
Yes.
59. 59 under section 3762I, read with.
Today, your lordship, notice has to go here also, the POCSO case.
But notice has already been issued on 18/5/25.
Of your lordship.
Huh?
I think not solved.
Okay.
Not sufficient.
Notice by order dated 18/9/2025, although the notice was issued to respondent number 2. The frame for sort that notice is not sufficient. Means the state council seeks one more opportunity to serve respondent number 2. Respondent number 2 publicly inform victim and sponsor. Is the matter. How much time you need?
1 minute.
1 minute. I list it on 28.
Yes, sir.
28. Public.
60.
60 May, please. The appellant was sentenced for a period of 10 years for commission of offence under section 376(1), read with section 506, your lordships. The appellant served 2 years, 4 months during the retrial as well as.
You are appearing?
I've appeared for informal.
Okay.
I've sought the copy on the last
Yes,
occasion.
yes.
This is for only bail, your lordships.
Hearing.
On the rate to a.
Only for bail. Yes, your lordship. LCR is there, your lordship.
Yes.
My lord, this is a case, your lordships. This case has been filed admittedly after delay of 6 months, as it is admitted in the FIR itself. Lost by the father. If your lordship will take to the FIR, LCR is there, your lordships.
Who is the prosecutor?
The prosecutor is
PW?
PW 14.
14.
Yes, your lordship. Here the prosecution examined as many as 18 witnesses to prove the case, your lordships, out of which the independent witnesses, if your lordship will take.
No, 14, 1-4.
18 witness.
No, who is the prosecutor?
Prosecutor is my lord 14.
No.
15, 15.
13.
13, sir.
13.
14 is the caretaker.
What kind of mentally disordered lady?
That was there.
Already appeared.
Usko is there.
Notice has already been served.
Notice already been served and.
I'll pass it over. Mr. Maharaja has already entered appearance. Let us see. He may come. Yes, next.
62.
Within 7 days, Millard.
Yes, I am passing.
Within 7.
Yes.
At item 62, only 2 years conviction under POCSO.
2 years.
Yes.
Undergone?
My lord, undergone very now my lord interim bail, and this honorable court also passed the interim bail also by the order dated 26/11/2025 while admitting the appeal. In the meantime, the victim also appeared, my lord, and
So Lordship, kindly see the victim, there was a marriage proposal and thereafter the entire things happened.
I am appealing for the, what do you say? Thought said 2 years. No, I don't. I have no objection. No objection. Where is that interim order you said? Interim bill?
2611, your Lordship, kindly see this honorable court part there. 2611-2025.
2 months, huh?
Thereafter, he was interim bail by the trial court, and thereafter this honorable court also, while issuing notice to the informant, victim granted interim bail for a period of 6
Have you filed an extension of time? Liberty was granted to you.
Liberty was granted, but thereafter I have filed, but the London trial court issued NBW against the petition.
No, you are supposed to file the application here. That's the order. Have you read that order?
Yes, my lord, I have filed here also. That is 164.
Where is that application? That application has not yet been considered.
IA number 164 of 2026.
That, where is that IA? 160?
164.
164.
My lord.
Okay, you are seeking extension.
My lord.
When the interim order is expired?
Interim order was, my lord, passed on 2611. Thereafter, I have filed one application there. That was rejected on the NBW issue, and I have filed the IA that is on 12th January.
Well, he doesn't have any objection. Okay. You have not surrendered then?
No, man, not surrendered.
Where is the NBW order?
I have filed in that miscase, my lord, that this is the order.
Now, when you move this application, the extension application.
Extension application I have not moved, my lord.
Why have you not moved the application?
That was not.
Then there is an order, you should do it.
Para 14 of that order.
You don't comply the order of the High Court.
My lord.
Despite you got relief. High Court, while giving you interim bail, liberty was given to you to ask for extension.
Yes, my lord, I have filed your lordship.
Where have you filed?
Immediately, my lord. That is the order reflected there, my lord. Your lordship, I have given.
Show me the order in this court. When have you filed for extension of time?
Extension in the IA I have filed.
Where?
That I have given.
Which IA?
That is 196, my lord.
That is on 26 you filed.
No, my lord, on 1311.
Where? This is not filed here, sir.
Yes, my lord. That is the application I have filed here, my lord. That is number is there, my lord.
You are not able to follow. What is the order? What was the order?
My lord,
by this court?
My lord, order for interim bail before the London trial court.
No, it doesn't say that. Just see.
Yes, no, my lord.
Doesn't say that. Let us see last paragraph.
Yes, ma'am.
Last paragraph. Citizen get liberty for filing extension. Right on. Para 14, just read it.
14.
Para 14, read it.
My lord.
In such view of the matter, the petitioner is granted liberty to file an application for extension of time
for a period of
6 weeks. Where? You should have filed here.
No, my lord, in that, in trial court shall do well to extend
in such eventuality, the trial court shall do well to extend the interim bail for a period of another 6.
Yes, my lord.
6 weeks extended or not?
No. I have filed, but the London trial court shall that since I have filed not proper format, that was rejected and NBW issue. They are the order. You
have you challenged this order now?
I have filed on miscase, my lord. That is the miscase, my lord.
Let us see. 164.
Yes, my lord. 164.
Where have you said that?
In paragraph.
164.
Annex or paragraph 4, my lord, I have stated that the petitioner was earlier on bail and moved to the above noted appeal challenging the order of conviction. This honorable court.
Para 6.
My lord.
Yes. That para not para 6. Right.
And a copy of the such, my lord.
Para 4.
Para 4, my lord.
But petitioner is convicted for offense under so. When the appeal was admitted by the order dated 26/11/2025, the following order was passed in the bail application. Para 14. Mr. Das, Land Counsel for the petitioner, submits that pursuant to the aforementioned order of this court dated in 26/11/2025, the convict appellant has filed an interim bail application for extension of time for further 6 weeks. Extension of interim bail for further 6 weeks. However, the trial court by order dated 26/12/2025 has rejected the claim on the ground that it has not been filed in the proper format. In view of the same, the petitioner has moved the present application seeking the suspension of sentence, suspension of sentence. So entered appearance and submits for the victim and submits that he doesn't have any objection to the application for grant of bail. The petitioner, since the petitioner has been convicted, sentenced for 2 years, no? 2 years,
Yeah, 2 years.
for 2 years. He has already undergone how much, roughly?
Only some days now.
You should be ready with this information.
My lord,
I'll adjourn it then.
only 1 day or 2 days, my lord.
You tell me how much, at least I have to write something, how much you have undergone. After conviction, you want a bail, you don't know how much you have undergone. These are the small minimum thing, at least at your level, it should be there in the tips.
Not undergone, my lord, 1. Jama Rohin.
The kind kouchuntale undergone. Rohi kouchunti. Tarafta you want to be sure about it day after tomorrow.
No, my lord, it is in the
Be sure about
judgment, my
it.
lord.
No, I don't see. You have to be very clear. In the bail matters, at least you have to render effective. First you said that I have undergone some period. Now you say that I have not undergone.
Time being, I am not studying, my lord.
You are not sure about it.
No,
You want to keep something hide. Day after tomorrow.
No.
Day after tomorrow. Yes. See, this is how you spoil your case.
Nothing.
Be fair. I have not undergone anything. I'll grant it. Simple.
No, now
You want to hide something unnecessary.
It reflected everything, my lord. That's why I'm saying the
So
judgment.
therefore you are not sure about it.
No, I am not sure. That's
So
what I'm saying,
see, I have to make, this is a judicial order. I have to
My-
record something. You must tell. Day
In the
after,
judgment, your lordship, everything.
day after tomorrow.
63. Conviction under section 376 AB, read with section 4 POSCO Act. That the victim girl is stated to be
Notice is
8
sufficient.
years, and your lordship may
Notice
see
service.
the medical evidence.
1 minute. You are appearing?
I am-
Okay. He is appearing. He is appearing. Yes.
PW. I'd say
Okay. He is appearing in any case. Yes.
the victim girl was examined very day after the incident. Now the doctor PW19, lordship may see for a moment.
What is sentence?
Sentence 20 years.
20 years. Undergone period?
That is the minimum.
Period undergone?
Period undergone 1 year, 4 months, 3
Okay.
days.
Okay.
And your lordship may see the doctor PW19, and thereafter I will go to other evidence.
PW19.
19, the doctor who examined the victim.
Are you ready?
I have no objection.
Sorry?
No objection. If you-
They are relations, my lord. My cousin. Accused
You
is
don't have any objection?
PW19.
Wakalatnama, have you filed Wakalatnama? Yes.
The report is the girl was not.
May.
Yes.
Here the appellant was convicted under 354 and 323
Yes.
and 4 years conviction. Out of 8 months is in custody.
How much you have undergone?
4 years. I have undergone 8 months.
8
months.
From 2/11/20 to 14/12/20.
Yeah. Released on bail. Then 17/12/25 to I am in custody.
4 years.
Yes.
What about the antecedent and all?
No antecedent.
Get a report. I'll call for a report and then I'll consider. Yes.
Oh, like that.
Yes.
67.
I have filed a beginner petition.
Sorry?
My name may be.
Yes.
67.
Yes, sir.
In last occasion, your lordship called for.
Have you got the custody certificate? It's not there. Received or not?
No, they are not received.
Right. The order dated 22/7/2026 has not yet been complied. The State Council seeks one more opportunity. Means the matter Read. Later was taken. Yes, next. 68.
In the applicant who is 21 years old. Huh?
Informant mail. Petition copy has not been solved.
Petition copy, extra copy दिया वाला भी तो अपना appear कर ले.
No, sir, notice only one mail. No copy.
Notice?
Notice is issued.
You have received notice, no? Just see, everything is there. What will you do in the bail application? See the evidence.
Petition copy is not there.
See the evidence. Bail application, 2-page bail application, what will you do? Yes.
Here the appellant is 21 years old now. And the victim is 17 years old. And the petitioner was convicted on 363, 365, 376 1 and grade with 4-1 of the POCSO Act.
The victim PW?
PW 5.
Let us see PW. See, he was 20 years at the time of. Are made, what to do?
नहीं है cognizance भी pass कर दो नहीं.
Chalo. Anyway, next. 69. Yes, madam.
The appellant was facing trial matter for offense under section 302, 201, 34 IPC matter.
It has been admitted already.
My lord, no, according to,
I think this is coming first time.
yes, my lord.
Not
Yes,
even-
delay is there, my lord. Delay is there. 18 days delay, my lord. First
300.
18, 18.
18.
Yes, ma'am.
Okay, 18 days. I'll condone the delay. For the reasons stated in the application, delay is condoned. Appeal admitted. Realization of the fine paid. And what are the offenses?
Offense matter conviction matter 304 part 1 and 34 IPC.
Notice. These three applications of the trial court record is received. Yes.
My lord, similar matter, another co-accused, my lord, that case is adjourned to 12th August, my lord.
Similar matter means co-accused.
Another co-accused.
Co-accused. What is the number?
CRLA 4 of 2026.
4 of tag with it. Yes.
That case, my lord, a call for case जो
But all-
criminal antecedent,
The land counsel for the
custody certificate.
convict appellant submits that in the case of co-accused, the trial court record has already been summoned. Since this matter is tagged with that, trial court record may not be summoned. Yes. Yes. 70.
20 minutes ago, it was filed timely, but the certified copy was not filing within the time, so there is a delay of 24 days, my lord.
Well, condone delay to get it. Yes. This is for admission.
My lord, for condonation of delay, my lord.
Offense.
Offense 20, my lord, section 6 of the POCSO Act.
Okay. For the reasons stated in the application, the delay in filing the appeal is Sunday. Admit as notice the application, stay up release. Yes. 71.
71, my lord. I have filed one appeal.
212 days.
No, my lord, Lordship may kindly have a glance. I have filed appeal CRLA 403 of 26 with a delay, but the appellant being inside custody, he preferred a jail criminal appeal. That is there in my Lordship's board. In that jail criminal appeal also, I am appearing. So let the jail criminal appeal be there, my appeal be.
I'll list this matter along with that they will see.
Nahi, didag aswa missing.
Achhi kya ji?
Didag.
Okay. Where is that?
Didag.
Okay. Then the first item
First item, Lordship may simply withdraw, permitted to withdraw.
Okay, right done. First item, Ms. Mishra seeks to withdraw this appeal.
Power bhi assi.
Since against the same impugn judgment and judgment of conviction and order of sentence, jail criminal appeal number 35 of 2026 has already been filed. Okay. Okay.
ଆଉ ତାପରେ jail criminal appeal ରେ delay ଅଛି 114 ଦିନ.
That I'll condone. Yes.
Admit କରି LCR ଟା ମାଗି ଦିଅନ୍ତୁ। ଆଥରେ conviction ହେଇଛି 3 ବର୍ଷ।
Jail criminal appeal ରେ 35 of 2026 ରେ
3 ବର୍ଷ conviction ରୁ
appeal this jail criminal appeal suffers a delay of where is the delay, where is the report? Where is the report?
So,
Where is the report? Use
that is there, my lord.
Is there?
It is reflected in the JCR. This appeal has been received from jailgate late by 114 days.
114 days. Huh?
And the-
delete of what 114 days. Since it is jail criminal appeal, for the there is no application.
My lord, application I have filed IA for bail and stay. The
No. Condonation of delay, there is no application.
no
Delete
criminal
Delete
application.
condone. Yes.
And the conviction is for 3 years. The appellant is inside custody for nearly 2 years.
Call for the custody certificate. Will conduct and independent lease the matter on.
Notice टा बेगा कर दियो कारण 8 October है जी conviction.
Notice issue notice to the victim also. Lease the matter on 21st. Get in report 21st. I'll not adjourn further, I'll tell you. Because out of 3 years, he has already undergone more than 2 years. Either this way or that way. Yes. 72.
But 21st month.
please, 72. Yes. Yes, sir.
Let's see this surrender certificate I am submitting there.
It has not yet been admitted, it seems.
Without
What is this?
pay the permission without the surrender certificate.
What is this?
Surrender certificate. While admitting the case, my lord, the bail application was heard and 1 month.
It has to be admitted first.
Yes, the last order, my lord, lordship kindly have a glance.
There is no order last order. Where is that?
Lordship in 1885, I have annexed that order.
188?
Honorable court has granted.
72, na? Item?
72.
Where is that?
4/26. Yeah. 20th of May 26, there is an order. Granting
Where is
1
that
month.
order? There is no order of this court.
Lordship, in the IA, I have annexed that order.
IA number?
1885, 2 days IA.
Which order?
At flag C, my lord.
Yes.
Lordship order 22/5/26.
Why this order is not there?
Hard admit.
20th of
434.
May.
Equal to 434, not 22. No. Why this order is not there in the court? Yeah, it's already been. Huh?
IA number.
No. Why this order in 434? It has already been admitted. Where is the order? Why it is not there in the order sheet?
Order sheet. Order date 25/26.
See the notice has been. Notice service ED. Service not affected. Service on the respondent number 2 is not affected.
Yes, that notice, victim notice is not.
Record right. By order dated 20/5/2024. Notice has been issued to respondent number 2, the victim oblique the informant. But the service has not yet been effected. The state council is seeking the last opportunity to serve the respondent number 2 through the IIT. IIT, of course. Which police station? I said which police station?
Ballypatna, near Bhubaneswar. Ballypatna.
Huh?
Ballypatna.
Ballypatna police station. Please the matter immediately after effecting service. Yes. Yes.
Perception, this is a statutory appeal, my lord. 1 year, 14 days during trial, my lord, he was in custody. And since 10th of July, I am taken to custody.
I'm listing it
is-
immediately. I mean, listing it on 14th, yes.
73, 74 months. It's an application for bail, conviction under 498A, 34 and 4 DP Act, my lords. And the conviction is for a period of 3 years, my lords. Out of which 73 had already suffered 4 months in custody, my lords.
73.
Yes, ma'am.
Yes.
She is the mother-in-law, 74 is the father-in-law.
73 is for father-in-law. 74 is mother-in-law.
24 is father.
नहीं, हाँ, 74 is mother-in-law, 73
Reverse.
is, yes.
Mother-in-law,
Yes.
74
Yes.
is father-in-law.
Yes.
3 years in conviction.
Yes, what do you say? 498 and all. Both of them have undergone about 4
Yes,
months.
the mother-in-law has suffered 4 months and the father-in-law has suffered 7 months.
From the
judgment, my lords.
From the judgment itself.
At page 12, my lords, it is seen date of arrest and date of release on bail, my lords.
What about husband?
Husband, my lords, the split up trial is continuing against the husband.
Absconding.
Yes, ma'am.
That's the conduct. Okay, we'll conduct. Jail conduct and released it on 17th. 17th.
See, they were on interim bail, my lords, for the past 2 occasions, my lords. That interim bail has expired, my lords. If that
When let us see interim bail.
My lords.
3726.
Order dated 3/7/2026.
Included consider and for final hearing.
It's a appeal of 2026 now.
No, when the interim bail was granted?
3/7 granted 25/2026.
Thereafter?
Subsequently extended by the order dated 3/7/2026.
Considering submission made on the ground taken in the application, period of interim bail granted in terms of order so we are extended till 23/7/26.
Yes, my lords. They have not surrendered as of yet, my lords.
Comply this order, I'll be granted.
My lords. My lords may keep it to next week. We'll
comply this order and be
grateful, my lords.
When the appeal was admitted on same order, admitted on 20/5/2024, the convicts were granted, initially granted 6 weeks.
Yes, 1 month.
1 month interim bail, which was subsequently extended
Yes.
up till 23/7/2022. The lead counsel for the petitioner appellant submits that the appellants have not yet surrendered, had not yet surrendered. And he submits that let the application be stand about to 20th of May, 21st of August. Sorry, 24th of August. Meanwhile, he filed the surrender certificate.
Let's keep it prior to 21. On next week, any date, Malats?
You surrender after 1 week. AGT you have already violated.
Malats,
after 1 week.
Both aged local, that's all.
I'll grant bail, but you should have complied with this.
Malats.
By now, you should have surrendered. I have granted bail.
Yes, Malats, I understand.
Okay.
By next
surrender after a week or so that it will be adjusted.
Malats.
AGT you have already violated. Let it be. Yes.
Deeply oppressed.
Then could
74, 75, 80, 84.
Yes. Next.
75.
Yes.
Petitioner challenge the order of dismissal of the consumer appeal on due to non-prosecution. Thereafter, the appellant filed a review petition with a petition for condonation of delay, which is also dismissed. My humble prayer is, since the order is passed in violation of.
You are referring?
Yes. Opening for 2 complaints. This petition is not mechanism. There is provision before approaching national consumer dispute resolution commission.
Which provision?
This honorable court also in similar matter manner did not incline to.
Yes. No, this is a different story altogether.
My lord, in the identical case, a coordinate bench of
This
the
is a different
court
story, sir.
also held that since the order is
His,
passed,
his review petition has been turned down on the ground of delay.
limitation.
The appeal was dismissed for non-position. The appellant remain absent on 6 appeals. Complaint person also.
What is the consumer complaint, by the way?
My lord,
What was the consumer complaint?
consumer, my lord, only dispute only in respect of my lord, double payment to purchase a garment, my lord. 5,000 some odd, my lord, only 26,000, 2,600 2,600 amount is additionally paid as per the complaint of the complaint.
Then the dispute is regarding 26,000. 26,000.
The compensation award is 35,000, my lord.
35,000. Okay, let it be 35,000. How much you have spent in the litigation?
My lord,
Twice you have gone to the state forum, rejected, review, thereafter High Court. How much you have spent for this? And how much how much time you have wasted for the courts? Only 35,000.
my lord, if lordship you are directed for mediation also.
Why? What mediation? What 35,000 you have been coming to state forum, district forum, High Court. You might have spent lakhs of rupees for this.
My lord, 35,000, then also 5,000
Well, let it be 40,000. How does it make difference? Unnecessary read petitions are pending for no reason.
Only my prayer is.
And these all are ego issues.
Decided
That's
on
all.
merit, my lord.
All are ego issues. I'll pass some order, then you will go to Supreme Court. You spend another 5-6 lakh rupees for recovery of 40,000 rupees.
My limited grievance, my appeal may be decided on merit. So that.
Tell me on the merit, I'll decide. So your appeal.
Merit,
I'll decide on merit.
My lord,
Is there any substance in the appeal?
Yes.
If there was substance, you should have prosecuted it. You didn't go. 6 times it was adjourned. And thereafter you file a review, that is also, time barred. How much interference you need from the courts? I think you put an end to it. Finish it up. Let it go.
An opportunity to.
It's all right. Technically, you may be correct, but see, practically what is happening on the ground. How much you will. The complaint was filed in 2018.
Yes, sir.
Today we are in 2026.
District forum also the expert also. That is why my prayer is my appeal may be decided on merit.
Where is the appellate court or where state commission's order?
State commission order, my lord, page 23.
20?
25.
25 years.
Then in the review, page
5 days you are absent.
20, my lord.
Rightly dismissed. Rightly dismissed.
As per the rule, my lord, the learned state commission also can decide on merit in absence of.
But if you don't, why should you will remain absent?
My lord, because of the lawyer who was.
Where is show me the application? Where you explain
in the limitation petition, my lord, can you see the impugn?
Where is, no, show me the application.
28, my lord. Pence,
yes, 28, yes.
The learned state commission also mentioned that reasons taken before the learned state commission, my lord. The ground for non-appearance.
Yes. Show me the application for continuance of relief. Where have you filed?
Like that petition has not been annexed before your lordship.
I'll pass the order. Yes. I'll pass the order. That is the only annexure you are supposed to file. You didn't file that.
My lord, I will just file.
No.
I will file.
I'll pass the order. I'll pass.
My lord, I will file that.
You give it.
My lord.
Give it. I'll just give it. I'll pass the order. Huh? Take it. Huh? No. But give whatever you want to give. I'll pass the order. Yes. Take it. Huh? Take it. ना लिख दो ये दीजिए respondent cases.
And this is office copy of the review petition along with that.
Yes, I'll do. I'll pass you. Don't worry. Yes.
But I have also supplied copy of a coordinated bench.
Yes.
Available.
Yes.
76. Item 76, one of the petitioners expert in the meantime. We're also trying for settlement before the court bill. And taken up after 4 weeks, in the meantime, it may be disputed.
Is there any interim order?
Interim is the stay for the post.
Oh, that's
That's it there.
who is appearing for the other side? Yes. Is it so that you have settled this?
We actually will be filing a new wakalat now because all the advocates are in state panel. So we'll.
Okay. In any case, it has to be adjourned. Okay. Release the matter on 7th September. 7th September. And shall I record that you are going for out of court?
We'll come back. Today itself we will talk. And we'll come back on that.
That is going for the petitioner. You are appealing for petitioner submit that there is a scope of the settlement, out of court settlement. Leave the matter on. Yes.
77.
77 last occasion, my lord wanted to know
Wait,
whether
Mr.
charge sheet has been submitted or not.
Wait, please, your lordship. Your lordship, item 77, pass to your lordship. Kindly.
In this case, Lord, we shall seek some time because of the receipt from the IAS that the preliminary charge sheet hasn't filed, but they could not supply because of the program of the Honorable President of India. So I pray that next week we can produce some document. The preliminary charge sheet hasn't filed, but they are not conducted.
They file na.
Here we copy of the charge sheet.
Release it next week. Let it be on then 19th. 19th. 19th interim order to continue. Yes.
Oh, there is no.
No interim order. Okay. 19th. Yes. 19th. Ketra material. Password. Yes.
Notes. My senior Mr. Dhol is appearing for the petition notes. I was suggesting that it taken up tomorrow. But he has some.
Hearing it.
No, tomorrow will take.
He has some.
Tomorrow, instead of tomorrow, it will be taken about 10th. One day again.
Tomorrow you tell your junior. You tell. Somebody should be there from your office.
On 10th.
Yes.
Item 81. That is filed against the Union of India Income Tax Department in the prosecution case. Mr. Parijay is appearing. So we have received the instruction. Because some communication gap, other councils are not given their controller. Fix a particular date on that date.
Commencing 17th, not 17th. 1 week they can.
You fix a date, but don't take adjournment.
No,
on that day.
we will complete it.
Your lordship may say 17th or 18th, whatever is convenient.
You tell 18th or 17th?
18th, yes.
18th. But no adjournment.
No.
This way or that way, you argue and finish it up.
Correct. 18th, no, interim order to continue.
Interim order to continue. 18th. Any problem? Which party?
Oh, hearing, 18th. Yes.
Hearing was it now?
Any problem?
No. I don't.
18th, huh?
18th.
Not with him, no problem. He is very cooperative.
But a short written note of submission is possible.
Both
that will be easier.
Easier, yes.
Shall I fix it at 2:30?
Yes, it is better.
2:30, so that I'll take it up at 2:30.
Yes.
Yes. Item?
Pass over item 1.
1. I prefer passing of the proceedings. Victim has to appear, joint deputation file.
Offense?
376.
Here, the background of the case is there. The prisoner is the victim, both are held from Sunavada and the Pumna police in district of Mavada. due to dearth of work in the locality. Both of them went to Chhattisgarh, stayed there for 6 months as husband and wife. They worked in a
164 statement recorded.
Even if you may admit one thing, there was a fix of a day on that both parties will appear before the voting session of the matter.
No. Sessions, sessions is quasi. What is the stage? What is the stage?
This trial is not yet come.
What is this? Charge has been framed. Evidence has already been.
Instruction, my lordship.
Huh?
We take the instruction, my lordship, because 162 statement is also not with
By the time 2012, 2014, with consent of family member, they both get into.
I am not interested to go into merits.
Yes.
Merits, then they're different.
No,
story.
here the information.
That's right, but I just want to know whether 164 statement is recorded or not.
Yes.
And whether the trial has already commenced, whether her statement has been recorded.
Trial is not yet.
It's 376.
64 mainly. Keep it.
What he has said in 164, that has to be seen.
Then keep it one adjournment.
You get all the instruction, madam. Meanwhile, just see.
Yes, ma'am.
Okay.
Fix up it so that
If she has said something in the 164 statement, now the affidavit has no relevancy.
It is under the old act.
Then the only thing what I can say is request the trial court to record her evidence first, preferentially. They will not support you. Then obviously, she will be out. That is the only thing I can do. Once 164 statement is there, now by way of affidavit in this court.
For one short adjournment, you will fix up a date.
I'll adjourn. Okay, I'll adjourn. Please on 20th.
20th August.
August.
And if I will take instruction also, their statement.
Meanwhile, they'll take instruction. Yes.
Item 28. 28, that is the case, release of the cash. In exchange of cash property surety, my client is agreed to pay that.
Who is
Husband is there regarding cash, loss figure, and the two other judgments.
Want to furnish property sheet.
Subject to verification of court below and.
Yes, if a lordship permits, I'll just take 2-3 minutes. So for that proposition, I'll address that one. But the question of law involved in this case is, during the continuance of the investigation in a DA case, during the continuance of the DA case, a particular amount, 1,83,000, 1,39,023,000. I'm sorry, this is 1 crore, 39,23,411. That has to be released, my lord.
No, only cash 1,84,000. I am confined to my impugned order. That is 1,84,000.
That was seized in total.
That is why.
My point is, my lord, during the continuance of a DA proceeding, the continuance of the investigation, whether this amount can be defreezed, my lords. This is on these particular points, my lords. My lords, I would like to bring to your lord's attention that there was a trap case.
This is a DA case.
Initially, it was a trap case. The doctor was trapped. That subsequently leads to a DA case. House search was made. And this house was made on 27 November 2023.
What recovered? 1 lakh?
84,000.
84.
I have mentioned that in lieu of that, I will give property surety.
183. 183.
Regarding cash, which will affect the
Lordship can turn to the instruction I've received. My entire endeavor to impress your lordship, the investigation is continuing, my lord.
What is your average timing for filing charge sheet in DA cases?
In a DA case, my investigation is continuing. Lordship can see the last.
No, what is the average time you take generally to file charge sheet in a DA case? How many years you generally take?
No, instituted in 2024, my lord.
Therefore, I am asking how much time you generally.
In the last bench, I appear, my lord, Justice Satpathi's court. I gave the tabular form, my lords. In the meantime, we have disposed of almost all DA cases open investigation concern. We have filed a charge sheet, my lord, in most.
How many years you have taken, by the way?
No, that was earlier, but it has gathered momentum.
Now, how much time? How much time you take generally?
Generally, all the old matters have been closed, my lords. all the matter. That government has taken a special tribunals to, to close all those DA matters, my lords. So for this case, your lords, you can on to the last line, my lords. The last line, that it's the investigation is continuing, my lords. Well, on that score, my lord, the petitioner, but in his petition, stated that, my lord, in paragraph 4 of that petition in this case, my lords. Initially, it was a trap case. A particular PS case number was registered. There it was turned to a disproportionate case, my lords. In a disproportionate case, that amount of which is short to be released, my lord, was found out if was seized from the house search, and it was also taken towards the assets of the accused, my lords. And now the question went down to place for Lordship, my lord, that paragraph 4 of the petition, the petitioner stated the charges is already been filed.
Now, if it is released, it can't be taken. And it can't be factored into the charge sheet.
This is my endeavor to impress your lordship during investigation.
What your investigating officer is writing. Just see last paragraph.
Yes, my lord.
He says that since it is to be factored into the income,
towards the assets,
therefore you don't release.
No.
Once it is released, it can't be factored.
No, that's not my argument. That's not my submission. What I submit, I bring to lordship notice, my lord, a judgment of this one, the Honorable Supreme Court, my lord, which came before, after your lordship judgments, my lord. Which the lordship judgment also on the basis of another Supreme Court judgment. My lord, here the question was, I just bring the, I just read a few lines only. Lordship can turn to the para 2, my lord. I not this particular issue that's pertinent to whether section 102 and 18A.
Which para?
Para 2 contains the question, my lords. The question relates para 2.
Yeah.
First page.
Yes.
First page, para 2, my lord. This contains a short, significant question regarding the 18A. That's a attachment provision under the new act, my lords. And 122.
Para 2, yes.
That includes
where the proceeding
102 or 18A. That's a new attachment provisions incorporated in that 2018 amendment, my lords. Lords, you can skip out that, my lord. Lords, you turn to the next page, para B. That's why that was the issue before the London Trial Court in Calcutta, my lords. Pursuant to the complaints, FIR number so-and-so came to the register. During investigation, certain fixed deposits held by the respondent's father of the main accused was frozen. An application was filed before the City Session Court, Calcutta, seeking defreezing of the said account. The same came to be rejected by Lord so-and-so. And what is the orders? He is 93 years and various ailments. Lords, you can turn to the next page. The findings of the London Trial Court, my lord. Lords, you go to the next page, my lords?
Yes.
Next page says, my lords, as the investigation is still in progress, I give you based on that. Right? As the investigation is still in progress, I am unable to enter the prayer for the petitioner to defreeze the fixed deposit rejected, my lords. Then against that, my lord, the matter came to lords, turn to para 4, my lords. The matter came to the High Court of Calcutta, my lords, West Bengal. The order of trial to reject the application for defreezing the accounts was challenged before the Calcutta High Court. The judgment of the order dated, so therein, therefore, setting the findings of the trial court and directing the defreezing the accounts. Allowed that once. Allowed that one. Turn to the next page, my lords. My lords, operating portion start from 18, my lords. Accordingly, freezing of the bank accounts of the petitioner set aside. The opposite party is directed to defreeze the said accounts within 7 days from the date. This is the orders which was asserted by the state of West Bengal before the Honorable Supreme Courts. Apart from answering this 18A to prevail or 201, so far the defreezing concern or freezing is concerned. Apart from that, the
what Ratanlal says?
Well, Ratanlal says that 18A was introduced in the 2018 Amendment PC Act, lords. That's attachments. Once the attachment procedure is there, that section 120 should not be resorted to. Well, that was turned down, my lords, and also Supreme Court said no. That pertains to attachment, but here the power of the police to seize under section 102 CRP still remains more. Lords, you can talk to para 15 says that thing, but let's just skip that. What I want to impress your lordship, that is at paragraph 16, the conclusion. Your lordship permit to place that one. Having decided the points of law as above, let us now turn to the facts of the case. The respondent is the father of the main accused. Although he had submitted certain response to the source of the money present in his accounts, the same was found to be a justiciable explanation by the investigating authorities, and as such, seizure was effected. The release of the fund so seized was rejected by the trial court, but later accepted the High Court on the premises that the same had been carried out on an erroneous interpretation of the law. We don't agree. we have now the important line starts. We have held that as above that section 102 CRPC being distinct from the power of the procedure as detailed under section 18A of the PC Act would apply to this case. Generally, with the setting aside the order of the High Courts, the matter would have been ended there. But, Lords, important, my Lord, saying the investigation has been completed, my Lords, because the stay order, I will place that. And the final report already stands present in the case. The freezing of the accounts of which fixed deposits are undoubtedly part may or may not be required. Considering in the light of the principles enunciated in para 9 of the judgment, we may observe as per these orders of the issuing notice 27 January 2024 have stayed. Here the High Court stayed, the Honorable Supreme Court stayed that matter. That's why Lord's investigation completed. State that operation of the impugned order. This may result in two situations. One, where the account stands released. B, is yet to be released.
Further read further.
If the situation is a burner, then the respondent there would have either a redeposit, and the amounts are furnished as tangible
Redeposit the amount or furnish
because
tangible security or bank guarantee
because
of the like amount. That's what I'm going to do.
Your Lordship can see the distinction feature is, my Lord, their interest is completed because the stay orders. Here the interest is continuing.
But no. Main distinguishing factor is that was defreezing of an account in this case. It's not a defreezing of account. Once account is defrozen, the account start running. So therefore this order was passed. And at the same time, the Supreme Court says that either a tangible security or bank guarantee can be furnished.
There no doubt, no dispute. That is also Lordship views on the basis of the Supreme Court judgment.
Yes, too.
But my entire, the final aspect is, my Lords, that whether during investigation is not completed, they also not ascribe any cause of negligence.
When are you going to file the charge sheet? You tell me. If that is the case, I'll hold on. Get the instruction and come. If you are saying that it can be decided after the charge sheet is filed.
Yes.
Then you tell me when.
There's no embarment is there. Then you can on the basis of financial
security. You tell me if that part if you are insisting upon. You must tell me
what is the tentatively time. I'll come back to you.
You can't hold on his money and take it together and say that no.
I'll come back.
I'll keep it. When do you want?
Tentatively, how much times? Correct.
2nd September? 2nd September. Yes.
Item 34.
Tomorrow. Not tomorrow. Keep it up to 2 weeks. Yes. 2, 3 weeks. Yes. Yes.
Item 61. No, 54.
33 pass over?
54 would have skip
54.
54.
53. 53 pass over.
53 pass against the.
Call 53. Yes. Who is entered appearance?
May I please, Lordship? As I have addressed on the first half, that the
the informant who Vasant Kumar Naik. For informant, Vasant Kumar Naik has entered appearance, but he is not there anyway. He is not there. What to do? Yes. Yes.
He has undergone more than half of the sentence awarded. 6 years sentence is here. And in the main period, he has undergone judicial 3 years, 7 months, 8 days. So that is the question so far the consideration of the bail. Also marriage, there is a case because what I found from the judgment, the court below committed error relying upon the hearsay evidence, discarding the evidence of the victim.
Who is victim? PW?
victim one, that her evidence was not believed.
Let us see. Victim one. Huh? What was the age of this girl? 9 years. 9 years. Who is doctor?
PW4. PW4.
Oh.
There is nothing in the medical evidence.
Yes. No, it's one and a half months after she was examined, I collected a sample of the victim life. Yes.
Now, your lordship have a glance to the judgment passed by the London Trial Court. At para 25 of the judgment.
Yes.
More particularly clause B, which has been analyzed by the London Court below, and he disbelieved the PW1's claim regarding penetration, rather believed the evidence of PW2 to 2, 3, and 8, who are the hearsay witness heard from the victim. So, basing on the evidence of PW2, 3, and 8, conviction was recorded, and the evidence of PW1.
Which paragraph you said? 25A.
25B.
B. PW1 claim to the accused in general connection to the line of 4 times and in the house and 5 based on inquiry results and process interestingly, PW2, 3, and 4 referred from this project to the accused was Yes.
And accordingly convicted under section 10 of the POCSO Act instead of the offense for which
the girl is only 9 years. You may not be understanding what is happening. The girl is only 9 years old.
That
you may
is
not be
true.
understanding.
That is true.
What is happening.
Who
But
punched-
the fact remains that see, the medical evidence is also not supporting. So therefore.
And the penetration part is not believed by the court.
Yes.
and he has already undergone more than half of the sentence awarded. These are the points involved.
Yes.
Second, PW 11 because of
11.
11, yes. Page
PW
91.
11. PW.
I know the informant of this
Hey,
case.
1 minute, 1 minute.
Right. Yes, page 91. Paper book also page.
PW 11, 1 minute. PW 6, 7.
So the
Yes.
1, 2,
13.
3, 4.
11, huh? Yes.
Yes, yours. 1, 2, 3, fourth last question. Fourth line. From the bottom. The family members of the victim had called some gentlemen, including me. Sudhakar Devri, there they disclosed the above act of the accused. We discussed the matter. There the accused touched the feet of mother of the victim and begged apology. He admitted his guilt. Then the informant lodged the report at the PS. Again in Pidol 2 also, the accused admitted his guilt, but the informant did not agree with this. He lost the affair.
That's a different story. He admitted.
Conviction to the
Conviction is not on the case of it. What are the evidence you have to tell me? Whether he admitted he doesn't. That part of the evidence of the victim has not been believed. Because doctors also says that.
Yes, sir. But Pidol 3000 yes. In Pidol 3, your lordship, she is the grandmother of the victim, your lordship.
To whom the girl has first disclosed?
The grandmother, your lordship. Yes, your lordship. Para 2, the occurrence took place 6 months back at about 3 p.m. I was sleeping on my veranda. The victim was playing near me. The accused
Yes.
Item 54, Lordship. May kindly pass over your Lordship.
My lord, I am for informant. मैं आउट डेट को रखूं.
Oh dear.
Lordship, solid.
18th, yes.
Obliged. 61.
Yes.
The conviction has been made by the law and trial court for 20 years of RI, and it is and the petitioner is wrongfully wrongfully
What is the period undergone? What is the period undergone?
Below 2 years. There were already 2 years he has been convicted.
Yes.
Below the whole conviction is based upon the girl, the victim girl is was pregnant. But below there is no DNA report has been produced by the prosecution before the trial, long trial. And below please see the page para number 33, page 102 Millard.
102 of?
102 of
paper book.
One the original petition, Millard. The appeal.
You are appeal, okay.
Yeah.
Yes.
In the para 33, which is the PW6 and the IO of the investigation, he said that after receipt of the medical report, I sent the biological samples for the chemical examination. I have not mentioned any explanation for sending the biological sample after 60 days of my receipt. During that period, the same were kept in the police Malkhana. I had not mentioned the Malkhana serial number in my CD. But she know that the IO himself know that the
come to the victim's statement first.
3. PW3.
PW3. Page. All this point which you are arguing, you can argue at the final stage. For the purpose of bail, just give me this evidence of the victim and the doctor.
Minor got PW3 victim, PW4 is the doctor.
PW3 is the victim. Okay, let us see PW3.
Direct implication.
What was the age at the time of incident?
16 years.
She was studying, pursuing a study in the Biju Patnaik Science and College anyway. Doctor?
04, page 93.
No forceful intercourse has been
8 weeks, 3 days, 40 years.
Yes. Milord, the doctor said that the fetus is a 59 days fetus at the time of testing. But the kidnapping, the alleged kidnap has been done on 8 October
And all
2000.
these points, the discrepancy and all, you point out at the time of final hearing. 20-year sentence. The victim says that repeatedly you have done. And the doctor says that she was pregnant. That's all for rejection. What else you need?
There is no DNA test report.
And those things you argue. These are
It is just strong prima facie that the fetus is not done by the petitioner at all. And it is after convincing this minor girl, they have done this false deposition before the trial court only. And this is my point. There is no medical evidence at all. And also there is a very...
what will happen to the evidence of PW4?
PW4 Milord, there is also no, she is not confirmed that this fetus is...
PW4 is your enemy.
No, PW4 is not mentioned that...
Why PW3 has implicated you?
Milord, he has been completely biased by her parent.
Why?
To grab only the...
Why bias against you, not the entire world? Why selectively bias against you?
Milord, that's I'm telling Milord. Milord, just my...
In 313, have you said that?
Milord, just the victim girl has came from her house, and the petitioner is a friend of her. And
No. Petitioner is not the sister.
No, Milord.
Petitioner
Petitioner is a friend. They wrongfully they have written all these things. Petitioner is a friend, and he only helped to communicate with his father.
You prepare a note for your argument. Get ready for the final hearing. All these points can be heard there. Yes.
Milord, only the
appeal for the final disposal in the due course. Yes. Next.
Milord, kindly letter from interim bail also just about 2 years as well.
20 years and yes. Next.
79.
79. Last of the directed to take instruction from the state.
It's got the order dated 14th February 2020.
Yes. Got any instruction? Have you read this order? 14 to 2023 order.
Yes, Milord. Update के CD as well as the report of the that from the report from the Lalbagh that is not been issued.
No, you are supposed to get the instruction. This is 23. The order is February 23.
79.
14th February 2023 order. Yes, see. The report hasn't come.
Report has
2023, sir. Consequently, the IO of Lalabagh PO's police station, case number so and so, is hereby directed to submit a report for consideration of the court. Where is the report?
let it come day after tomorrow, my lord. The noting said that 3/5/24 that report say about that not been attached in the file. So I will day after tomorrow we can.
By the order dated 14/2/2023, the IO of Lalbagh PS case number 294 of 2020 was directed to submit a report in regard to the release of gold ornament of the petitioner. However, the report has not come on record. State Council seeks a last opportunity to obtain instruction, release the matter on 18th of August. 18th August. It's made clear that no further adjournment at any cost on any pretext shall be granted to the state to obtain instruction. Yes.
19th, 18th.
19th, okay, 19th. Okay. 19th is 19th, okay. 19th.
19th.
Yes.
Item 80.
Region out of elopement, my lord. The victim and the mother of the victim has also appeared. The victim has alleged against the informant, my lord. Here the informant is the brother-in-law of the victim lady. My lord.
What are you seeking?
I have challenged the FIR, my lord. So in her 164 statement, she has already stated that I have been in elopement with the and I have gone with her. I've gone with him. My brother-in-law has posted this case.
Yeah, charge sheet has been filed?
Yes, yes.
Huh?
That report
Where is
my-
charge sheet?
My lordship dated.
Except FIR, you have not filed anything.
No, my lord.
Charge
By
sheet
that
is there.
time- by that time
Charge sheet has been filed.
Charge sheet is there, yes.
On 20.
What are the offences?
18 charge sheet and filed.
376 2N.
Yes, my lord.
Charge
framed
2M and
Charge has already been framed.
yes, my lord.
What about the evidence?
So
6
is
Pokso
also
is there
there
and
and
ST
ST Act is there. They are appearing, the victim and mother of the victim are appearing. The informant is not appearing.
But 164C has implicated you. How
No,
do
my lord. No, my lord. Not again implicated.
show me a 164 statement?
No, my lord. I'm having the 164 statement, my lord.
Yes. And also she has also deposed before court. Let us see.
In 164,
164 I have.
164 statement, she has deposed against the informant, my lord. Name is Bhutulu Ram. He is OP number 2, my lord. And while the petitioner was in custody, the mother and the mother of the victim and the mother both they appeared and filed affidavit to the effect that the matter is going to be settled. That is in the BLAPL, my lord.
No, have you read the
yes,
164?
And my lordship also observed that my lordship ordered dated 26/2/24.
Yes.
My lordship has observed and I have 26/2/24.
Yes.
And now, my lord, the victim is married in a separate place. The accused is also married separate place. Both are living their happy marital life, my lord. And she does not want to pursue this case at this juncture, my lord.
Despite this kind of 164 statement, how have you filed the charge sheet? Let us see the charge sheet.
Yes.
If the prosecutor says that nothing has happened, how have you filed the charge sheet on 376? What is the evidence you have? Box, everything you have included. In 164, the girl says nothing has happened. What evidence you have? Let us see the charge sheet. Let me examine the charge sheet first. How have you filed this charge sheet?
On 27/12/2018, that doesn't file.
Let us see the charge sheet. You have recorded this evidence of 164 statement of the victim
Yes, ma'am.
girl. She says that nothing has happened.
Yes, ma'am.
Despite that 376 and everything. Let's see, come to 11, page 11 of the charge sheet. Page 11 of the charge sheet.
My lord.
Para 18. Flag C. Flag C. Huh? Copy of charge sheet. Read it. 18. Read Mr. Das. Have you ever seen a charge sheet of this kind?
Brief fact of the case during the course.
Brief fact, just read it. Brief fact.
During the course of the investigation, Bengali PS case number such and such, dated 38/18, 363 IPC, 31 SCST Act, and
have you ever seen this kind of charge sheet in your life?
360, 376, and 6 POCSO, read with the 31 of
It
the.
is certain that it is a true case. Charge sheet file. 164 statement is this. Who is this IO?
Yes, Udgata.
Whose statement is recorded? What is the evidence? Nothing is there. Have you, Mr. Das, have you seen this kind of? Honestly, you tell me if this is the kind of, and the offense is so serious offense.
Yes, yes.
Let's see.
ঝর্ণা ওরাম।
What evidence you have to file this charge sheet? You read all 161 statements of all the witnesses.
161 ସେ କହୁଛି ମୁଁ ଗଲି ମେନ୍ ରୋଡରୁ ଗଲୁ ମେନ୍ ରୋଡରେ ସାଙ୍ଗ ହେଇ ଗଲୁ
କିଛି ନାହିଁ।
160
ଚାର୍ଜ ସିଟ୍ ବି ସେମିତି ଫାଇଲ୍ କରୁଛି।
161 statements are like that.
This IO doesn't deserve to continue as an IO of police.
IAC କେତେ ଦୂର ସେ DSP ଟା DSP sorry ସେଟା 3G act ଅଛି
And who is appearing for the victim?
I'm appearing.
Yes, what do you say?
Nothing to send that. I have already deposed before that.
Where is the affidavit you filed? Where is the affidavit?
Filed the affidavit. PL number. He has not filed. His mother has filed. Though she was minor by that time.
Where is that BLAPL or
BLAPL is. It has been tagged minor.
1037, huh? This is the affidavit.
1037 of 2019 minor.
ठीक, I'll pass. In 2019 it was filed, huh?
Yes, minor. But that time she was minor.
No, this affidavit was filed in 2019.
Yes.
Then now they are married.
No, they are married separately, minor. As because this petitioner was in custody by that time.
Verify the authenticity of this affidavit. Day after tomorrow. Day after tomorrow, verify, otherwise I'll call that IO here. How has he filed the charge sheet like this? On merit also I'll pass it. No case under 376 is made out at all. Forget about settlement and all. Verify it. I am not going too far. Verify it by day after tomorrow, the authenticity of this affidavit, and tell me. And whoever may be the affidavit, the IO. Otherwise, call him. Call him here. How has he filed this affidavit? Charge sheet? Without any application of mind. No evidence is there. Nothing is there. Okay. He is BS. What is this? IO of which police station? Deputy Superintendent of HDPO, Sambalpur.
Yes, ma'am. The
7th, huh? I'll take it on 7th. Verify, because this affidavit was filed in 2019. Was there any stay in between?
Yes, my lord.
Stay.
It was there, but last occasion, your lordship, the order could not be dictated.
Anyway, there was a stay operating.
But it has not been extended, my lord.
Where is the stay? Let us see whether. Was there any stay? Whether the trial is proceeding in between.
Yes, ma'am. 26 to 24.
26 to
24.
Okay.
Second page number.
26 to 2024.
24. Yes, ma'am.
Yes.
Further proceeding stay.
Further proceeding stay. Okay. Then trial must not be good. 7th, huh? 7th. You verified the affidavit. Veracity of the affidavit filed by the mother of the victim on 4/9/2019 is to be verified by the IO of the case. And yes.
That was initially the FIR was lost. And that was registered under section 304A. And when charge sheet has been filed, then filed under section 304 of the Indian Penal Code. Here the case that while doing appendicitis operation in a hospital, here the doctors and the hospital manager, they are the petitioner for lordship. So
petition number 1 is the doctor.
Yes.
Petition number 2.
1 doctor, then
3.
also 3 doctors.
Kalpana Baral.
3 doctors.
They are the paramedicals. Who are they?
by order dated 8/2/2026, plus the state was directed to produce a report of a committee.
3-2.
Report of committee. Committee was directed to form by the Hon'Ble Court to know whether the doctors are competent enough to
Clearly order
do that.
Paragraph
5.
Five, huh?
Yes.
Considering the above, this court direct to the superintendent of to constitute a committee of experienced doctor to give their opinion on the issue involving here and which shall be produced before the court. Shield cover. The report has come.
Is that the
Shield cover report is there.
and that report has come? Yes, last time.
It was there. Very shield cover report.
Page 110.
Page
110.
1101.
The next page.
Yes.
Yes. Plus here the informant had also approached the Human Rights Commission. It's a state Human Rights Commission. There the matter was compromised between the parties. And the informant received rupees 5 lakhs from the present petitioners. That I have filed.
Who is appearing for the informant?
Pardon?
Who is appearing for the informant?
Was appearing Lakshmidhar. That additional affidavit is there. That is at Alex Flag B.
What does he say?
Flag B, also we can find that is the affidavit that at page 8, joint compromise petition filed by petitioners and opposite parties.
An additional affidavit by the petitioner.
I have filed.
Yes.
I have filed. I have brought it to the notice of this whole court. The conduct of the informant, because they are close before the OHRC, they just came forward for a compromise and received rupees 5 lakh. Then they are pursuing here with the hope that they will get more money. What I feel was. And the informant is appearing. One day informant said, we want to refund back the 5 lakh rupees. I am having the draft with me. We'll pay back the money. We'll contest the case. Then sometimes he's not coming.
No, that is a different story. I am not interested in that, whether you settle or not. Whether any case is made out or not, that's the issue. Who is appearing for the complaint?
In this way, because now, after going for a compromise, now proceeding again before this honorable court, that apparently is malicious. That is covered by 1992 Supreme Court Bhajanlal's case. It is a malicious proceeding, that part. And so far as the cognizance order is concerned, cognizance has been taken under.
What is the report of the committee now? Committee reports. What does it say?
112, page 112.
112.
Yes.
It's not a committee report. Doesn't look like. The chief medical officer only. What does it say? It's then it is just see, read the report. Read the report. Read the report. Have you read? The report?
Yes, my lord, they have given a copy on the last occasion. That is,
if you read the report for the chief district medical officer,
in compliance to the letter by the inspector in charge, Bienpur Police Station, Barampur, received on 5th March 2026, the committee is of opinion that Dr. Prabhat Kumar Paningrai, the
where are you reading? Where are you reading? Committee?
Is
112, my lord. With reference to the letter on subject cited above, I am to inform that.
Which letter, which date?
My lord, that is the date 25th February 2020.
No, 6/3/2026 report. 6th March 2026.
No, ସେଇଟା ତାର enclose ହେଇଛି ସୁଯୋଗ.
ଆପଣଙ୍କ ପାଖରେ ଅଛି ରିପୋର୍ଟ ଟା? That was being shown in the open court.
Have you gone through the file or not?
Yes, I have.
Tell me
In obedience to the order dated 1/12.
which letter you are reading?
My lord, that is a page 110. My lord, that is the dated 1/2/26. In obedience to the order dated 1/12/25, I have the honor to intimate you that in the above mentioned order, the honorable court has instructed to obtain the instruction as to whether any opinion of the expert body medical board was sought for before the filing of the charge sheet. After going through the case record, it is found that letter of CDMO Barampur Ganjam, dated 22/2/20, has been sent to the scrutiny of the document and opinion regarding the negligence of the part of the treating surgeon and staff. On dated 26/2/20, a letter from the office of the chief district medical officer, public health officer, Ganjam Barampur, filed letter number such and such, Barampur, dated 25 February 20, has been received in connection with the Vidyadharpur PS letter number such and such, dated 22/20, for scrutiny of document and opinion regarding the negligence on the part of the treating surgeon and staff. Both the letter are enclosed herewith. My lord, then my lord, that the letter, that is 25 February 20, my lord, that is page 112.
26 February 2020 letter you reading. 26 February 2020 letter.
2026.
No. 26 February 2020.
2020?
Yes.
That is the two opinion, and with reference to the letter subject cited, I am to inform that.
Last letter from the chief district medical and public health officer, Ganjam Barampur. Reading?
Pursuant to the order passed by this court, that is the letter dated 26/2/2026. That is the office
But
of the,
read this letter. This letter says something.
I'm reading that opinion. The expert committee meeting was held on.
No, I am saying something, you are reading something. You read 26th February 2020 letter of the chief district medical officer. Both of you have not properly seen the file. Properly prepare and come. Lease it on 19th.
83.
Plus interim.
19th.
There is an interim order for the content.
Continue. Yes.
It's matter, my lord. The petitioner filed an application for sending the check for chemical for expert opinion. So the learned trial court has rejected on a hypothetical basis that it should have been filed after 243(2), after recording of 313. That means the petition filed the application before the stage of recording accused statement or 313 comes. On that sole ground, the court has rejected.
Show me the order.
Yes. May I invite your attention to page 30, the last operating part.
Annexure 6. Annexure 6.
Annexure 6, Milan.
Yes.
6. Because invite kind of the last part.
Yes.
In that last line. So because the application was filed.
Read the book.
Yes. On the above said ground, the petition dated again Chabichi filed with the accused stands rejected as it is filed prematurely. Put up for recording of statement of the case. 313. So my
What is the order passed in 2593?
No, only accused statement has been recorded. So this application may be.
Come with clarity. What is the order passed?
On 313.
No. On the criminal MT number 2593 of 2023.
Yes. So for recording of statement of the accused, that means 313 statement of the accused.
I'm asking something, you are answering something else.
We asking you.
The impugn order refers to a criminal miscellaneous case number 2593 of 2023. What is that?
Oh, Chart 3. This honorable court, sorry, I beg.
That's what I'm asking.
This honorable court directed to make an application at the appropriate stage. So after closure of the.
Where is that order?
Yes, that order.
It is annexure 3.
At 3.
Annexure
3.
Yes. Read it.
Page 27.
Only minute. May I read that page 27? At the appropriate stage.
Yes. Then appropriate stage means you have filed it after 313, everything is recorded at the end. When you saw that you are going to be convicted, that time you move the application. That is the appropriate stage according to you.
Appropriate according to the appropriate stage.
Means when?
After closure of the prosecution evidence.
Prosecution evidence closed.
Then
accused statement is made and everything. Thereafter you move the application.
That's why
Why have you moved that application? That is not the appropriate stage.
If you also permit me, the case is under the summons procedure. Perhaps the learned conducting advocate thinking that this application summons trial. In summons trial, the question of 243(2) doesn't arise. So probably that has been swayed the.
Not probably. You tell me the right thing.
254 is a summon procedure. 130 is the summon procedure.
What is the check amount, by the way?
Check amount is not 32 lakhs. 32 lakhs.
What is your stand? You have not signed the check.
So for this issuance of check, yes, my case is that some blank check. See, the complainant was an employee with me, and I have kept 3 blank check only signed. That has been misutilized by the complainants.
You show me your reply to 330, 130.
Legal reply.
Yes.
That reply to legal notice I have not found.
Show me that. That's the whole case.
For the moment, my
You can't think of something and start, in the initial opportunity when you got. Was it your case?
What was my explanation?
Yes.
That explanation is that.
Show me that 138.
That
B.
That is
not
annexure 2. Annexure 2.
Annexure 2. Let us see.
That is their written statement.
Yes.
Page number 20.
Annexure 2, page
20.
20.
First sentence.
Yes.
I'm placing my.
That on, yes.
That on 8 Saturday, the Reconsi at about 8 a.m., the complainant stated before the accused that at sudden about 10 lakhs rupees is required to purchase agriculture product for his business Godam, as the accused has to go outside of his district for 2 days in some
emergency work.
The complainant fondly obtained signature of accused on the 3 numbers of blank check, including the alleged check number such and such, in respect of his accused bank account number such and such of the Bank of India Connecticut branch on good faith to withdraw the money required for his business, and the said check book, including the signed blank check,
as well as other blank check was kept in the table drawer of the accused Godam under custody of the complainant. So she has stated that the accused has signed the check, but he has not taken a plea that he has not filled up that check. But now he is taking the plea that though I have signed.
The defense is altogether different now. 138 notice, where is the notice? In the notice, what stand was taken?
Notice they have not.
Show me the notice.
Notice I have not annexed.
Show me the that is the basic difference.
I'll call it. They're not true because against
Well,
the
now you have seen the judgment. If you initially have not taken a stand, subsequently you can't keep on changing. These are summary proceeding.
I understand.
Therefore, the first opportunity is given to you.
Legal notice.
You have to disclose your defense there. And then the defense which you are going to take, that you have to prove.
First,
in the trial, because the presumption operates against.
Yes, reply to.
You can't keep on changing your defense depending upon the type of evidence led by the complainant. It is not the normal criminal procedure. It is a summary proceeding.
That's all.
Then I will collect accused has not filed any reply to the legal notice. I have mentioned.
It's very difficult for you. Can't be sent like this.
Next week.
Fix it for 27th. Yes.
84. My lord, 7 my
27th.
27th. My. Oh, bless.
Yes.
Obligation, no. I play your lordship.
Yes.
The petitioners before your lordship. One is a associate professor working in SC Medical College Hospital, and the petition number 2 is an advocate, practicing advocate. They challenge the quashing of the criminal proceeding, which was initiated on the basis of the report submitted by one Navakishore Das. At this stage, I will go to the background for why the quashing application has been filed. My lord, the petitioner's family have a deity, and they are the father of the petitioners is the marfather. So some persons encroach the land for which they applied for demarcation of the land before the Tahsildar. But the Tahsildar somehow or other, being otherwise influenced, did not acted upon. So the father of the petitioner approached this honorable court. A direction was issued, including the police personnel, to demarcate and remain present to maintain law and order. The date was fixed, which is the date of occurrence in this case, my lord. That was on 24 to 23. And while the process was going on, the present case informant, along with their associates, they came there, they created disturbance and assaulted, for which one of the petitioners sustained injury in his person, and pursuant to that, information was lost. Corresponding to the same, Tangi PS case number 38 of 23 was registered on the basis of the written report lodged by petition number 2 minor. Thereafter, one of the associates of the present informant who was figured as accused, including the informant, another affair was also lodged on the same day. Both the cases were investigated, and so far the first information report lodged by the petition number 2, that was ended in submission of the charge sheet, including the present informant and their associate. So far the other case which has been registered, that was under section SC/ST Act, that was ended in final report. So the time of occurrence and date, place has been mentioned in the 2 earlier cases as I submitted, and the third case for which the quashing proceeding was initiated, what happened? That gentleman came forward in the year on 26 to 23. Your lordship, 24 incident.
After 2 days.
2 days. Lodge a affair alleging the same date and place of occurrence as mentioned in the earlier case, and place was changed. Now your lordship may imagine both the parties initially admitted that place of occurrence is at a particular place, date and time is same. Now one of the associates, they come forward, shifted the place of occurrence, and ultimately charge sheet was submitted. So I have filed all the documents. For better appreciation, I have a humble request before your lordship. The State Council be directed to call for all the three cases so that it can be give a clear picture.
Yes.
Tinta PS case number they do chisa.
You get it. See, for the same incident, there are two FIR initially. And both the FIRs ended in closure for, report. And thereafter, a third FIR after 2 days is filed, changing the place of occurrence.
Only changing place of occurrence. Time
and the incident and everything appears to be same. So that's what his case is. So unless you see the other two FIR, you can't assess the court. Give the FIR number.
Yes.
You see the final form in those two cases. Yes.
I am for the informant, your lordship, and I am virtual mode. I beg apology, my lord. I am virtual mode, my lord. I am for the informant in this case, my lord.
Yes.
Lordship, state may be directed to obtain the injury report of me, my lord. Because on same day, my lord, my senior is seeking for quashing, my lord. I am injured. I am injured at 11:30, my lord. Then I have shifted to hospital. I was stay there, my lord, for 2 days. Thereafter, after returning from the hospital, I have lost the FIR, my lord. That is my case, my lord. The other things
But
I get.
you have lost the FIR after 2 days.
After returning from the hospital, my lord. I was hospital. It is admitted
No,
fact, my lord.
for 2 days. For 2 days you are in the hospital.
Yes, my lord.
That record may be called for. I have no objection. What my friend said.
Now the prosecutor is there. He has heard it. Just see. These are the things you have to. Okay. We'll list it. 20.
There is a IA, your lordship may further proceeding be stayed. Till then, road date of your motivator.
No, there is no stay order. As
No,
past
no.
as
Previously there is no.
Then see, there are 6 hearings taken place. 6 hearings are already taken place. What is the stage?
Stage appearance of the accused person.
Only appearance. He is going to 20 years.
Your lordship may till then stayed.
No, once stays then it goes on.
No. On that day it will be completed.
Okay, what only appearance? You don't appear. You move 370.
Your lordship passed order in that light.
When the date is fixed? Next date?
Date के भी अच्छी नहीं.
When the date fixed? Before trial court.
Date didn't.
Tell me the date. Before trial court. Either I list it before that day. Give me date. I list it before that.
Any motion will be made.
Yes. You give me the date. What trial court date? Then you accordingly I'll pass your. Okay.
Yes, sir.
Let the date and tell me.